Are we ready?
Yeah, I think this is enough time to give people to log on.
Okay, then I'm going to go ahead and kick it off. I want to thank everyone for joining us today. Ryan just told me I'm making introductions. So there is Ryan Marquez here. He is I actually don't know what your title is, Ryan, so maybe you shouldn't have told me to do this, but I know he's a clinical professor at the University of Houston Law Center. He, as many people in Houston and beyond, have always been a great mentor to me, and I've learned a lot from him, and I hope you will today as well. We also have Eric Qualtler, and he was also a clinical professor, I think, because I don't know anyone's title, at South Texas College of Law, Houston. And he has also been a great person to bounce things off of and to cuss when I'm frustrated with something. And sorry, I don't know if I'm supposed to say that, that's being recorded, but I'm just gonna let them start. I think y'all all know who they are. We do have a question and answer and a chat. I don't think this is intended for more newbie people, but I have a feeling we have non-newbies on here. If you know an answer, I think we have it set up so that other people can answer questions as well. I will be monitoring it and letting Eric and Ryan know. If I know that something's coming up later, I'll let you know. But otherwise, please feel free to post in question and answer or chat. And let's go, Ryan.
Welcome, everybody. We also have with us, you might hear a few other voices chime in to what we're saying. We have Mari Carmen Dollar, also from Houston Volunteer Lawyers, and Donna Carney is also available. So if you hear other extraneous voices, it is because we invited everybody to just kind of give their inputs on anytime there's any of the subject matter we're talking about. So you guys feel free to add your statements to anything that I'm discussing. And as the purpose of this is, we all know that rental relief will be ending. And so it's good to get a review for especially all the attorneys that might be new. It might be a good idea to go ahead and figure out what to do now that rental relief is more or less it's ending. And so I'm hoping to just kind of walk through what I do or what we do when we get a justice court case and give y'all some ideas on and strategies for how can you handle these eviction cases when you no longer have rent relief to rely on anymore. So let's go ahead and begin. So the first thing, like for any case, let's just be honest, and it's no different for evictions, but any case that you have, you always look at the petition because the petition is basically the outline for all their claims and all their defenses. And there's some things that even as I've gotten back into doing some evictions, it's been a few years since I've done them on a regular basis. I've popped in here and there, but now that I've been doing them more on a regular basis, and judges are telling me that they're not seeing these things when I have motioned the court. For example, for your petition, the first thing you want to check is the name of the plaintiff. And for us in Harris County, we're lucky enough that we can just go ahead and go to the website of the appraisal district to search cases. So I'm going to kind of walk through what I look at. So here I've typed in a case that I had just looked at, picked a random one at first for this presentation, and I can look at it through our Odyssey system. And so I will go through and I will look at, for any case I have, naturally I'm going to look at the petition and see who the plaintiff is. And here, as we're seeing here, this plaintiff is SQ Houston Gateway, and it's an LLC. But also of note of this apartment complex is, it is also a DBA. So they're doing business as, or in other words, they have an assumed name that's called Gateway on Cullen. And as we're looking at this, if a business is operating under assumed name that's different from what they're registered in Texas from, then they have to have an assumed name certificate on file. And it has to be filed if they're an LLC or some type of other entity other than an individual. That assumed name, it has to be filed with the Secretary of State. If not, normally if you're in like county court, it would be abatement. But we're in JP court, and the judges there, we all know, kind of do their own thing. I've had, a judge tell me that by him reading it, because it says that the company may not maintain a suit, that he thinks that means that they have lax standing or they can't, he's going to have to dismiss the case if they don't fix it. And yeah, that can be true for an abatement as well. But other times, normally that's the appropriate term, is to give them an abatement and give them time to fix it. He's been giving them continuances to get this on file. And you might say, well, where can I look up and can I find assumed names, and where do I look at that? And where you're going to go for any type of assumed name searches is you'll have to get an account with the Texas Secretary of State through their SOS Direct system, and you're going to have to log on. So I'm going to go ahead and quickly log on, and it will pop back up once I have inputted my ID and password and my credit card information, because I don't know how to, if there's a way to get that saved. So I'm just typing in my password, and I can now resume the share. So now that you're logged on, where you're going to look for the assumed name, and actually this is also useful for any time you're dealing with landlords. You're going to want to see, you're going to want to look for the entity here. You're going to look for a find entity. And type in the name of the landlord. So here we're going to get SQ Houston Gateway LLC. And you're going to type that in here. Okay, and the search system will give you other ones that are similar, so you don't have to worry about being exact with this search, but you can see right here, it is going to be this one, SQ Houston Gateway LLC. So we're going to go ahead and click on this one to open it up to see what has been filed in this entity. Now, over here, you can scroll over to where it says assume names, and you go ahead and give this a click. And if you notice, it will say here, this is where you'll find any assumed names that are filed. Here, it's saying that there are no assumed names. If there was an assumed name, you would be able to click on it, and there will be a certificate that appears, and it will tell you what the name that they're transacting business under. And so here, we're going to look also on the filing history, because you can also, if you need to check to see, because it's if the name is different than the certificate of formation. So if we click on this, well, this one's not being retrieved, but it will, oh, let me try again. No, it's not, that one can be retrieved, but the name for the certificate of formation will be the same name. And so if I'm in a justice of the peace court, depending on the way your justice court is conducting themselves, you might have to either print this as a PDF, and usually what I'll do is I will print it from this assume name tab with this section that says no assumed names exist for this filing, and then I will bring it up to the court to let the court know that there are no assumed names on record. Now, there is a fee every time you do conduct a search. It is $1 for each search that you conduct. So that's something to be aware of. Every time you click that search button, it does charge $1. So I just paid $1 on y'all's behalf. You know, you can send me the contributions. There's about 100 of you, so a cent from each of you to make up this $1 that I've spent. But for each search, there is $1 that is spent. The other thing that you should be aware of is this is where you would look if it is a corporate entity. If it's an individual, then it has to be filed in the county where the property is located. So for us in Harris County, and for others, you'll check your county clerk records. So you would go to the real property records. Oops, that's not the right thing. For us, it's the Harris County Clerk, and I do understand that different places in different counties have different entity records availability. But I know that most of y'all are probably familiar, or if not, you should be familiar how to log on to your county clerk. And if it's something you don't know, you might want to make sure you you become familiar with that. So for us in Harris County, it's one of the records is over here in the assumed names. And you would click on that and do a search here if it's individual. So here I would look at Gateway at Cullen if it was an individual, but there is no assumed name even here as the business under Gateway at Cullen. So let's go back. Okay, and so again, what is the ramification if they haven't is that then the company cannot maintain an action in which the assumed name is used. And my argument always with these justice of the peace is that, or county court is this is one of the benefits of having a corporate entity is that they are, they get all the benefits as far as limited liability and all that. And through assumed names, it allows them to use a different name in business. But in order for us to be able to track the correct company, the code has specifically stated what is required to utilize such an assumed name. In the same way, the property code has certain requirements for a tenant to be in compliance with the lease, and in the process that they get evicted, so are there requirements for when you're using an assumed name. So the court shouldn't hesitate to go ahead and hold the landlords accountable in the same ways they hold tenants or landlords accountable when they're using or when they're evicting someone. Let's see. All right. Now, if all you have is an address and you don't really know where or who owns the property, because sometimes you'll see it in the website that all they do is they might only list their assumed name. Like I've had some petitions where all they show is Gateway on Cullen, and that might be all that they have. Well, for us, one good starting place, if you're going to have that type of situation, is to check maybe the appraisal district for your county. And so you can go to do a quick search. And here I'm going to search by address, and we have 1901 Cullen Boulevard. So I put 1901 Cullen, and here we are. We can see it's this one. I can tell it's this one because here we have for the square footage 242,936. So that's going to be the apartment complex square footage. So I'm going to go ahead and click on that. And if you see here, it does show that they're the owner. But anybody that deals with real property records knows that the appraisal district isn't the official form or isn't the official record here. And for Harris counties, you can look at ownership history. And if you click on this ownership history, it's going to pull open what the other previous owners. And this can be helpful because the next thing that you will want to do if you ever have to verify a piece of property and who the owner is, and if that ends up being part of what you're looking into, is you can go back to your real property records. And you can go ahead and select, let's see, where is property records? It's kind of real property. And you're going to type in here as the grantee SQ Houston. Let me just see if anything pops up. Okay, on this, some things did pop up, but what I go ahead and do is here you can look at for a legal description or something else to look into. I can tell from here there might be a neighborhood, Dakota at Cullen. So now when I go back to my web inquiry, I can just do a find for Dakota. Okay, well, so it's right at the top. And we're going to want to look just to find the deed to see if they're the actual owner. So here's the deed. And so this will help prove to me that this is the owner. And you can see this was that previous owner that it had showed, Cullen SH Apartments, who has now deeded it on this date to the new company. And you can see the date that they signed it is the 25th of September, 2018. That matches. And so if property title ever comes an issue, don't feel free to look through the code. And if you're worried that maybe they gave it to someone else or you want to see if there was a new owner, then what you can do is you can see what name they usually use is here. Sometimes I'll grab this and put this over there in the grantor to see if they've given it. I don't see anything there, and just in case, I'll remove that as well. Well, they've given something else. The only thing that they've given here are deeds of trust, which that's just basically the loan documents that is associated with the property when they purchased it. And again, like for one thing that you're looking here, I'm noticing here is this says Fannie Mae. And so I might want to look further into that because maybe it's federally backed or something if we're going to look through the CARES Act. So I might actually want to pull this up to see what this says. So UCC financing statement, and the secured party's name is Fannie Mae. So with this, then that might alert me that I need to maybe even look further into this to see if it is in fact federally backed. I might have to look to see if Fannie Mae has given a release on this property. So then we want to probably search back and see if there's a release. Well, here is a release that was filed this year. So those are the things that you can actually find out in the real property records. Okay, let's go ahead and go back. Okay, so that's where you look for the assumed names. There are some other things that you can check with the entities that you might be able to argue. Some of the times I'll find that the suit name is brought in the name of the management company. Well, the management company, they're not the landlord because they're not the owner of the property. And usually when you want to check the lease, to see who actually the property was signed by. So here, we're lucky in Harris County, a lot of the courts are requiring them to file their leases, so I don't have to go pull it. But if we look at the lease contract, the owner is SQ Houston Gateway LLC. So if they were using a management company such as Tarantino Management, or they're one of the big ones, then Tarantino should not be suing in their own name. And I have seen that a few times where the management company is the one suing. And so that you might be able to argue that that management company doesn't have any standing because they're not the owners. And you can even show they're not the owners. You could show the lease. You could show whatever you need to show to show that they don't have standing. The other thing is this one is a Texas entity, so it's not a foreign entity. But on one time I had in the lease, it even said in the lease, it is a Nevada company. And when I went online to check to see through that Secretary of State if they've registered in Texas, that Nevada company had not. And so when a company fails to register in Texas, then they can't, and they're transacting business. Now, owning property in Texas, it by itself is not transacting business, but renting property, then we can all agree that is a business, especially when you're renting out an apartment complex or have multiple houses, then that's a business because you're doing it to make income. It's not just passive investment. So them too, they were forbidden from maintaining an action in Texas. And that entity also, it was owned by a separate trust. And so they were never able to get, I think, in communication with the appropriate people to get a certificate of a foreign entity in Texas to actually cure that. So I think they ended up having to dismiss the case or let it be dismissed because they were a foreign entity and not there. The last thing that you might want to check is whether or not the entity is current on their franchise taxes. Let's see. And for the chats, Lisa, if you see anything chats that you want to say out loud, feel free to interrupt me, or if there's any questions, because it is a little bit hard to keep track if there's any questions at the same time. So feel free to interrupt me if there's any questions that you think should be addressed at this time.
I've been, I think I've been answering them in the comments. If y'all don't like my answer, please feel free to send me a private message or anything like that. Or you want clarification. I just do want to point out that Ryan, one person did comment that we should check the county records too for a DBA. And I did post the sections from 71 of the Business and Commerce Codes, delineating the difference between unincorporated persons and incorporated businesses, et cetera. So,
right. So, yeah, and that's when I went over to the assumed name records after I did see that comment too. And for mine, there is none because it was in the corporate entity. And so for the franchise taxes, you'll also notice it here. If the company is not in good status, it won't say just in existence, it will say forfeited due to franchise taxes. And also here in the filing history, instead of having public information reports, you'll see a tax status, but you might not want to pay a fee to find out about the franchise tax status. And you can also, if you want to, go to the state comptroller of public accounts. And this is actually beneficial for a few different things. Sometimes if I just want to get an idea who owns a property, or what a legal entity status is, I might start here instead of going there, because I might not want to pay any money. So I might type SQ Houston, and here we have it, SQ Houston Gateway LLC. And on the details, if I click on the details on the franchise tax details, it's still there's nothing that says it's not in good standing. They're still active instead of saying it's in violation. But what else you can get here if you want a shortcut to getting the registered agent name and registered agent office, if you have any demand letters for any other claims you might have, those can be obtained here as well. But before I file any official lawsuit or send any official letter that's required by the code, such as a DTPA letter, I go ahead and you can either call the Secretary of State to verify it, and that's free, or me, I just usually decide to pay the $1 to double check to make sure it is correct. But if you want just a quick to see who's the owner, you can look at that. You can also get a little bit of who the member is as far as the public information report. Like we can see they have a little bit different entity that is their main member, but if you want to send a letter to the member as well, you can also do that. And so that's also a good place to get some information, or if they're violating the tax account status.
I'm going to interject real quick, Brian.
Sure.
So often, especially in JP court, the person who's at JP court will have no idea any of this happened. Right. They'll have no idea about the franchise tax status. They'll have no idea about the DBA. And they will often say, well, I've never had problems evicting people before, so it must not be a problem. And the answer to that is, yeah, that's why we're there. So, yeah, just you can't be daunted. Instead, turn around on them and say, well, you need to get it if you want to prove that you have the right to transact business in Texas.
Right, and I think that's a good point. Is sometimes the judges, if y'all aren't doing these things, and when someone like me or Eric or any of them that we do them, they don't know what we're talking about, and so sometimes it does take some education on part of the judges to educate them. And so I'd recommend printing out the specific part of the tax code or the business and organizations code or the business and commerce code, because each of them are located in different places. And then once you show it to the judge, sometimes I find they're a little bit more receptive to listening to it. Because yeah, I actually had an attorney tell me, and this is an attorney, tell me that they didn't know what I was talking about, and they don't have to file an assumed name, that it's named there, and that's all that was required. And you know, I kindly told them that no, they're incorrect, and that if they can show me their assumed name certificate, I don't have to file, because this was in county court, that I don't have to file a motion to abate. And you know, they refused. They said they've always done it this way. No one's challenged them. The courts have allowed it, and so therefore to them it must be right. But then as soon as I filed my motion to abate and set it for a hearing, and we're there before the judge, you know, then all of a sudden he says he'll look into it. And then guess what? 2 days later, I get emailed a copy of the assumed name record they have filed with the real property records.
I saw a case once in which the opposing counsel said something about how they had done a property tax protest, and she had no clue. It was opposing counsel. She had no clue what the franchise tax was, and she completely confused it with property taxes and submitted records afterwards showing that the property taxes were paid.
Exactly. I mean, and so like even like your landlord attorneys on the other side may not be aware of these provisions, especially if they've been most of them, they're not used to having any type of real defenses put up or any type of a fight put up by pro se tenants. And so it might be a little shock to their system. And just note for the ones we're talking about here, this is really a one and done cure. So it's not going to be something that because from in the future, once they file their assumed name record, that's fixed for the rest of the tenants that particular landlord might have. So it's not something that's going to be an ongoing thing. This is just one thing. If you just need that little bit of extra time, it could buy you a little bit of time for a few tenants. And the court just reset 4 cases because they're all from the same landlord for one group of tenants. And we'll see, because it was people from Nationwide Eviction who didn't quite understand what I was talking about. And will they actually have the correct paperwork the next time we're back in court? That I don't know.
There was a good question about clarifying who the plaintiff can and can't be. Eric's been answering it, but I also just want to point out that something I see the mom and pop businesses make a mistake. They'll incorporate and they'll file the petition in their personal capacity. And I say they don't have standing at all if the property is owned by the corporation. And that's different from what Matthew's question was, which is a good question. If a management company has the authority to do so or is acting on behalf of the landlord, if they're filing like as agent 4, then we think that's okay. If the lease agreement is with the management company, they don't have to be the owner because the lease agreement gives them that authority to do so. And so it's kind of fact specific. And I know that may or may not help.
Yeah, right. And on that one, like I still have to research. I'm still actually myself, I have run across that where someone is filing for as an agent 4. And maybe they can do that, but that one, because some transactions, and it was one that I'm just still looking at, is for power of attorneys for real estate transactions. Sometimes they actually have to have the power of attorney and have it filed with certain ones. And I just have to go back and relook at that for the specifics, because I don't think leasing maybe was included in that list, but you do need to be aware of all those things.
And by the way, I have a plea with the jurisdiction that I filed in county court of law, contesting the court's jurisdiction to hear an eviction that was filed by a management company in their own name when they were not listed on the lease. So if anyone wants it there, you can just email me and I'm happy to send it.
Finally, if one of the codes, sorry, I don't know which one off the top of my head, says that for transactions involving real property, the power of attorney has to be on file in the real property records. Do you think an eviction is a transaction involving real property?
Well, that's what I'm saying. That's what I'm actually thinking about making that argument, or I kind of started making that argument, but I had to, I didn't have everything I needed from it because I didn't have my code in front of me, because that one's in the estates code and I couldn't find it while I was before the judge to see if what my gut was right or not. And I'm not sure still that it is, because I had time to go back and research, but that's what I'm talking about. Look at all the codes and work them whichever way you can with whatever law you can find, because that's something that might be able to be argued.
I want to chime in just with another maybe last brief comment that would work for this defense and possibly other defenses. If this is really the only defense that you have, and depending on the temperature of the JP that you're in front of, you may actually want to avoid raising this issue at JP court and kicking the case up to county. If your client can suffer the consequences of paying to the court registry, it may buy you some more time. Ultimately, some JPs may reset those cases, some JPs may dismiss them, and the landlord will just turn around and refile. Just something to consider with several of the defenses.
Yeah, that applies pretty much all these defenses, right? You want to pick and choose what you bring up JP. And it's always, that's the thing about this, you always have to decide whether winning a JP is actually the best idea. And it's a weird thing to be position to be in as a lawyer, but it is what it is.
It's that old adage, sometimes you have to take one step back to take 2 steps forward. And sometimes you might have to take a fall in JP court. Like Donna was saying, if you really do believe you could win in county court and your tenant can pay the money into the registry of the court, and they would qualify for a pauper's affidavit, especially if they get some type of government benefits or have a legal aid certificate where something could not very easily be challenged.
Also, remember, you only need the 1 month's rent if it's a non-payment case. So if you've got a holdover, then you have nothing to lose because they do not have to pay 1 month's rent to the registry. So, they can't, if they don't pay rent going forward eventually, then they could theoretically file a motion for default, et cetera, but your chances of that happening are pretty low. So you really need to make decisions on both conduct and holdover evictions on whether you want to bring any defenses up at all in JP or just tank JP or even default at JP and go straight to county.
Right. Now, the next thing that always I check in the lease agreement, in the lease contract, and in the petition is, are there any other tenants? So in this one, there's only one tenant. Let's see. Here's just one resident that's listed, and the resident in this lease agreement is the tenant. And if we look again at the petition, there is only one tenant listed, and it is the same one that I saw in the lease agreement. And the reason why this actually comes up sometimes is because I've had a few cases where there's multiple tenants, and I think, or one of them, there was like 6 tenants. There were 6 tenants, and naturally, I guess because of the cost of that, because the landlord had, that policy of everybody over 18 had to be listed as a tenant on the lease instead of an occupant. And so when they sue, they have to sue all 6 tenants. And the requirement under 510.3 of the Texas Rules of Civil Procedure under C, it says that the petition should name all the defendants. Now, there's a couple of ways that could look at that. I mean, most JP courts, I think, will still probably grant the eviction and just grant it against the one named tenant. But there could be an argument that they haven't pled everything and haven't proven everything that they're supposed to, because 510.3C says that they have to name all the defendants, and they should all tenants, and they should be made as part of the eviction suit. So, whereas, it's a little bit different than an occupant, of course. Occupants are just people that aren't subject and aren't required to be liable under the lease. They can be evicted with just naming the tenants, but it's a little bit different. So, you can try making that argument. One judge, I think he just decided to dismiss it. He was almost going to dismiss it on this ground, but I also had a notice to vacate ground. And so he's like, either way, I'm going to have to dismiss it. But he's like, he was kind of thinking that he would need all defendants there. And in practicality, if they've only named one of the tenants and not all of them, that tenant still has possession over the property. And so they could have other people who they want to stay there or invite over. All right. Okay. Next, like Eric was trying to say, or was talking about this, naturally there's other grounds that there can be other than non-payment of rent. And so each of these grounds is a little bit different. For ours in Harris County, ours also could alert you. One thing would be a main alert is if when you're looking at the non-payment of rent aspect, if there's any money paid by a government entity, that would mean it could be some type of subsidized housing or other government program. And each of those programs can have different restrictions. Even each of the entities, if they're taking tax credits, each of those have different ones. That's a little bit above for what each thing requires for this type of program. I just, though, if you do notice that, that's a red flag that, or if your tenant tells you that they know there's low income or tax credits, then that's an indicator that you need to look further into it, because sometimes there's all other additional protections for tenants that have those type of government payments. So we also have violations of the lease. This one, just like holding over, they're not going to require, and even though some JP court judges, I've seen them where they still want to put that requirement of payment of rent into the registry of the court. So make sure that it's clear that if it's just a conduct-based or a violation of the lease, that there is not that entry of payment into the registry of the court. Now, in a few of the different cases that I've had.
I'm going to interrupt you, Brian. The clerks don't always do it right. They're so used to processing non-payment of rent cases, they will just mark it up that way, and they will sometimes make mistakes. It can usually be resolved with a phone call. If it can't, I guarantee you that all of us have motions. I know I do.
Right, but but the main point is to make sure you double check your orders after you get those judgments to make sure that that's blank. Because you're right, sometimes I've seen it where they do it correctly and sometimes, or it could be as easy as if you're losing a conduct one, maybe alert the court, a judge as one final thing. I want to make sure that there's nothing put for the rental amount, because the judges are usually there, or for ours, are filling out the orders as they are are hearing the case. Sometimes you'll notice them filling out the order and filling in the rent amount even before they've decided whether you're winning or losing. And so it is another thing to look at. But I would say, even though there is no official rules of civil procedure or rules of evidence that are applicable in JP court, besides the 510s rules of or 500s rules in justice courts, what you need to realize is, to me, my argument is still, if it's not included in this petition, they cannot raise it orally at the JP court. And the reason why I make that argument is under 510.3, it does require a petition, and it does require certain things. It requires the description of the address, the facts and grounds for the eviction, a description of how and when the notice was delivered, the total amount of rent due and unpaid at the time of filing, and a statement if the attorney's fees are sought. It requires that to be in the petition. And so to me, it is still requiring me to be given fair notice and not be tried by ambush. And my argument to the judges is I was here prepared, or we are here, or the tenant was given service prepared to make arguments on this case. Not because now you're losing your non-payment of rent that you're going to go say, well, judge, he also has been doing this or that. No, that is not in the pleading. That's not why we're here today. And this is the reason why we're here. And it's strictly in the pleading. And I just want to make sure before I forget is make sure the address is correct, the premises. You'd be surprised. Just a couple of weeks ago, I had a case, and it was one of those smaller apartments that had only like 4 units. And they put unit 1 when he had been in unit 3. They put unit 3 and he had been in unit 1. And, I discovered this. I'm like, are you sure, sir? Take a picture of it and send it to me. Let me see. And then while he was on Zoom, he actually was able to, one of the best things about Zoom, do a trial, and anything goes in JP court. So he actually walked with his phone, he's walking and going outside. Okay, now turn around your phone, sir, and let's see. And it was like the big reveal that you normally don't get, on court TVs. He turns it around, and for sure enough, the door he walked out of was apartment number 1. And so that was easy win for the JP judge. He's like, I'm sorry, ma'am, I can't rule this. He's not in apartment 3, he's in apartment 1.
There's a question that wasn't sent to everyone, but what about a situation where the landlord's petition names one person who is deceased and no other occupant, and the actual occupant tries to appeal? The JP court denies the appeal, reasoning this occupant is not named in the petition, therefore cannot appeal, which resulted in a writ being executed against the actual occupant and his property. It does make sense to me. I've never had an issue where the JP court denied someone else appealing it, so I haven't dealt with this specifically because I have had unnamed occupants appeal. It doesn't surprise me to hear this happen though, because it's JP court. And Ryan or Eric, do either one of y'all want to make any comments about this situation?
Yeah, so someone just commented the exact right thing, file a suggestion of death. That's what we've done. I have had that happen before. File a suggestion of death, it'll scare them up real quick.
So I'm just going to say though, I was observing a trial this week in which the unnamed occupant said that the person named in the lawsuit was deceased. The attorney for the foreclosing mortgage company said, yes, that's correct. And it didn't stop anything. However, I'm going to say the judge ended up dismissing the case for other reasons that didn't really make sense and not for the things that would have made sense. And so the right result happened, but yes, normally it would be a suggestion of death.
Right, and if they know that, or if there's evidence of that, I mean, to me, it almost seems like there's a lack of jurisdiction because there's no defendant. You can't sue someone who is dead. You have to sue their executor or their heirs, depending on the situation. Now, as far as the occupants things go, like, yes, I've heard that as well. Sometimes some courts aren't listing occupants. And in that case, that you might need to file something in the county court. But what I always show is most of the time they list this right here versus this and all other occupants. So they are kind of still part of the suit. And, you know, we have filed appeals like in those, or in the past based on mortgage foreclosures, when there's been a tenant in there that's subject, you know, to the actual landlord that was foreclosed on, and they're an occupant. But, you know, the problem is then they kind of do make themselves a named person in the suit. And so other things, you know, they could end up with a judgment against them because now they've made an appearance and are named. And so that's going to be up to them because now they're taking a risk of being evicted, you know, because they're entering their name in there is what I would caution. So yeah, so going back to it, just make sure that all the grounds are only limited to what's in here in the petition. Now, the next thing, oh wait, let me see, there's a question, but I'm not sure if. Oh, I have a question in here. Don't the rules allow for oral amendment of the petition before trial? I don't see that in the rules 510s anywhere where it says that they can orally amend. I know that's listed other place, but remember, this is the rules 510s are more specific than the general rules applicable to JP courts. Here it's requiring a petition where that must be sworn to, and it has to include these things. So my argument has always been that no, they cannot do an oral amendment. The more specific provisions control over the more general provisions of the Texas Rules of Civil Procedure. So there should not be any type of oral amendment. And I got a comment about sometimes someone saying they sometimes allow oral amendments of rent. Well, most of the time for the rent, the way it's worded is the rent is owed at the time of the petition and all other rent as it may become due. And so that's kind of an ongoing type damage one. So that's a little bit different. My argument would be no, I would still argue against an oral amendment if it didn't have that specific language in there.
Yeah, but lots of the JP's forms even just say that, like.
Correct. Most of the ones in Harris County, at least, they say, and all other rent as rent becomes due each month. And to me, I think that is, you know, that is probably sufficient. Okay. So then the next thing, of course, that we're looking at, because, you know, now I've heard some discussion on notices to vacate. Now we call it, sometimes people use the term defense, but it's not a defense. This is actually an element of their claim, you know, and so make sure that there's that distinction, because I've heard some rumblings that, you know, some attorneys are saying, well, they didn't plead any defenses about a notice to vacate or the lack of one, or when we talk about that, and it doesn't have to be pled. It's their duty to make sure they're in compliance with the Texas Property Code 24.005. That's their duty. Yes, Lisa? You're muted.
If you're filing an answer, how do you label that in your answer then?
You don't have to. It's one of their elements. But if you want to be extra careful, then what I do is I'll sometimes and I'll give an example. I mean, I had a grounds eviction where I didn't think I should have to put self-defense, but it was one that constituted that, and I didn't think it was going to be required, but I put it both in affirmative defenses just in case and just other defenses. And I just had that other, but you don't have to necessarily plead that, because it's your general denial means you're denying all elements of their cause of action. And so that general denial itself should take care of any notice to vacate issues, because that's an element they have to prove.
Sorry, and I'm gonna just mention, I can't remember if it was you or Eric who told me this, but I think I used to plead it as an affirmative defense. I have quit doing that because it's not as explained, but
Right.
I will put it, I like to put it in my answers, and I do it as an other defense. And while I agree with you, maybe I should label it like more specifically. I don't have ideas, but sometimes I like to put it in there.
I put it under other information, or, I mean, my thing is, or you know, or as part of your general denial, maybe, you know, because because it's not a defense. And that's one thing we have to make sure and stick with the courts, that they don't get it twisted to where they start thinking we have to disprove notice to vacate. It's not something we have to disprove. It's something always that they have the burden.
Someone
Yeah.
suggested to plead it as a special exception. I don't think it's something that can be corrected though, although I appreciate the suggestion.
It could be if the problem is that they misstated it on the petition, but if they didn't deliver it right, then I actually, when doing an answer, I just do a general denial and bring it up at trial. Because, I mean,
Well,
why?
a special exception to me is when they haven't completely described it. Okay, if I say I gave a notice to vacate and I didn't say how and I didn't say on what date, that's special exception. If I said I delivered a notice to vacate on August 1st, 2021 by hand delivery, it's not, I can't then come in and amend and say I gave a notice to vacate on October 1st, 2021 by the mail. That's not so that's not the same thing, you know. And so if that is a new ground, or to me a new claim, and so that would be different because you're changing an essential element of your claim. It's not where you're giving more description as what's required under a special exception.
You could also just file a motion to dismiss. But you could,
Well,
but generally you want a judgment in favor of the defendant rather than a dismissal if you can get one. So I almost always just do nothing and bring it up at trial.
right.
So there's no real, with most JPs, there's no real advantage of giving, they're not going to read the answer anyway, you know, so at least the high volume ones. So just bring it up at trial.
And that's a good point, Eric, is remember the rules say we don't have to file a written answer. So do I ever? No. Why am I going to confine myself or limit myself? Because the things I'm talking about, they can be used against me as a judicial admission and the least, if not anything else. And so in JP court, I'm not limiting myself. I could have one typed up if I want to make sure I have something to refer to that's like out as an outline, but I'm not going to file it and tell them what my arguments are going to be. I'm never going to do that. And most of the time we're representing people on the spot, or sometimes I am. And so I don't have any answers or any pleadings. So I can't do that. So for the notice to vacate, you want to really look at it very carefully. Like, you know, is the time period required correct under the lease or law? We know if the lease is silent on it, that it requires 3-day notice to vacate, right? I mean, everybody, I think, you know, even people who are starting out, we know this. So when like I said, Harris County, we're lucky because they can go ahead and they allow us to look into everything. And so they actually, a lot of landlords, they're requiring them to file their notice to vacate. And here we are. So we pull their notice to vacate. And here's more proof that they're using an assumed name and transacting business, because they only use we don't see SQ Houston Gateway LLC. We see Gateway on the Cullen, which is something else. Here, if we look at this notice, one issue I'd have with this notice that they have filed is there is no name, so we don't know if this is addressed to the tenant, nor is there a property address that I see on this one. So they don't have anything listed on the property address on what premises is. So there's been no demand for any premises. They've just been given and if we look at it, I don't know that it even requires vacate. It does say a pay or quit 3-day notice, but here it just says to avoid further action against your account must be paid in full by 10 a.m. on the 30th of October, and failure to remit payment in full will result in management filing for possession of the unit. Okay, well, if you would like to return keys and skip out to avoid additional fees, please vacate your unit and return prior to the deadline. But I don't know that they've made the deadline clear. You know, this seems like this is the deadline to pay. Are they saying that it's for that date? But either way, the main issue here is it doesn't say what premises, and that's required on the notice to vacate. And if you'll recall, this one looks like it's in October, but that's very different than, you know, if they're doing a 3-day, they've only pled for one that is in July. See, they have here one July 19th, 2021 posted on the inside of the door. So this could be another issue with the notice to vacate. And I would argue that they don't have a valid one in this particular case.
I got to bring it up, Ryan.
Yeah.
24.005I, my favorite defense.
Leaving it for you.
So for a notice to vacate can't be equivocal, unless, as in it can't say move or pay unless there's been a demand for rent previously, and it has to be a demand for rent that was like consistent with the notice to vacate. So if they can't show that there was a previous demand for rent, then a pay or quit notice is not valid under section 24.005I. And I have shockingly won multiple times doing that. You may have to explain it and give the provision to the JPs, but it's still true.
Yes, Maria Carmen, you had something to
I'm
add?
just going to say, can you go back to that slide and show that? I think you pointed it out when you were looking at it, that it's not unequivocal.
You want to go back to the notice to vacate?
Yeah, the notice to vacate. I'm sorry. Yes. Because I've seen that several times. I've never reached that point, but can you just show which part of it?
It literally says pay or quit.
Mhm.
Yeah, that's helpful when it says pay or quit at the top.
Right, and it says failure to pay or remit, or if you'd like to return the fees and skip out.
I also
Yeah, and
just want to point out that sometimes I'll go with the best one because I don't want them to fix everything I'm not going to tell them
Right.
everything, which I think is one of the reasons why Ryan said maybe he doesn't want to file an answer in JP court. And I'm mostly filing them in county court at law. So it's a little bit different because I'm making a request for attorney's fees often, which is the main reason I'm filing an answer sometimes. But thank you, Jonna. But I just do want to point out that even though there's like 5 things wrong with this notice to vacate, sometimes it's just easy to go with the easiest one, and maybe they fix that one thing next time, but you have defenses for future tenants down the line.
Yeah, and a
Exactly.
lot of times when it's unequivocal or it's not unequivocal, they've messed up other stuff too, and you don't even get to that point.
Correct, and that's why do it piecemeal, even with your arguments to the judge, because these are JP court judges. They don't necessarily, I'll try one, and then when that one doesn't work, let me try the next one. Well, so judge, I think you should dismiss this case. There's not a valid notice to vacate. And then go to the next one. Oh, well, judge, they can't transact business. Now, usually I start, even if I notice with a vacate notice, I'll start just with the certificate of assumed name or the assumed name certificate, because that one will get me some more time. And then I'll make the vacate notice argument either at the JP court, or I might wait to the county court if the person qualifies for a pauper's affidavit and can pay rent. I just noticed a question that was posted saying that someone received a judgment in favor of their client, rent claimed in the action subject to the doctrine of res judicata. So that means the landlord cannot make a claim for rent. And this is a pretty common question. If the landlord doesn't have to join a claim for rent, which is like a separate suit, to the actual claim for possession. Those are independent claims. You could really win on the claim for rent, a landlord could, and lose on possession. But they don't usually know to do that or to make that argument saying, wait a second, judge, I proved up my rent. I just didn't prove up the remedy for possession. And so you will sometimes get a take nothing judgment. As long as your judgment is a take nothing judgment, then it would be preclusive to any further claims for that rent if the landlord does not appeal it. Or especially if it comes from county court, then it's over. If you get take nothing in judgment in county court, it's over because it has all been decided already.
So I will mention that when you've got a divided judgment like that for like you win possession, but lose rent, I have before asked for attorney's fees for winning the possession claim, gotten them, and erased the rent obligation with the attorney's fees judgment. So just because you lose rent, if you win possession, you can still, under the law, get attorney's fees and possibly mitigate that rent judgment.
Yeah, that's true. You're offsetting it, right?
I'm also just gonna say that if I normally get to the notice to vacate, I ask for a directed verdict at that point, and we don't talk about anything else. And so I'm hoping to take care of everything. Just point, just even though they're talking about the bifurcated remedies, it doesn't have to be that way, and we shouldn't be encouraging it.
Oh, no, yeah, I don't encourage it, but what I'm saying, just be aware of it. They are independent, but most landlords, they don't catch it. Kind of like I usually do see take nothing judgments. Even though once in county court, the landlord just said, I want my rent. And the judge is like, okay, well, that's nice, but you didn't prove up your cause of action. And so I'm gonna have to do a take nothing judgment. So the other thing that you have to be aware of is under the CARES Act, if there is that federal connection, and you can just go to the caresact.org and it'll pull up the same website. I checked it, it pulls up the same website, which you can then type in the property address and find out, oh, I saw it populate, there it is, 1901 Cullen, and search and see if there's any connection, because then you will find that you're required to do a 30-day notice. So in this one, it should be, this one, it doesn't have anything. So, you know, a 3-day notice under just the regular law would probably be applicable, except that I would want to verify that Fannie Mae a lien isn't still active, because that could be federally backed. So I don't know how comprehensive sometimes all of this is.
We have I know that we're almost at the break point, but there is a question that's a nice one. He says, many attorneys try to go back to JP court and sue for the rent they lost in the prior appeal. I've always argued the landlord can no longer sue for the rent that was subject to the prior judgment. If they did not get a judgment for rent, they are barred by res judicata. Yes, that's what I argue.
Yeah, and I've had it where I've used, I've used that, and it's worked before. I mean, they got to take nothing judgment in the JP court, had a copy of that up to county court. Judge, they can't do this. Or, you know, or when they gave their notice, they were no longer behind in rent because they had the judgment of the JP court and they didn't wait an additional month. Because let's just be honest, sometimes when you win, what's the first thing landlords do? They issue a new notice to vacate. If you've gotten a take nothing judgment, it's in the middle of the month and they've already claimed for October, then that take nothing judgment would have wiped out possibly October as well.
But if they're in the same court, I'm just gonna say, sorry, and I'm trying to not nitpick whatever, but a lot of judges will only award rent up to that date. So I don't know if there's an argument to be made that if you're on there on January 14th, that they haven't proven that they paid January 15th on.
Yeah, that's fair. That could be fair. It just depends on the case and the court, because
and you always want the take nothing judgment over a dismissal for this reason here.
Right. But most judges, and let's just be honest, JP judges, most of them are just dismissing cases when there's an invalid notice to vacate. Instead of giving an actual judgment, they're just dismissing it based on lack of proper notice. So most of them are treating it almost like jurisdictional, even though it's not. But that's what I notice. And to fight them on it, I don't know if that would be the best thing to do either. But I
That
suppose
might be a
Sometimes happens
reason.
in county court at law, and we just tell our volunteers, ask for the take nothing.
Oh, yeah, no. County court, or for us in Harris County, they're pretty good about giving judgments, you know, or at least when I've appeared, they know that if they lose, they'll give a take nothing judgment. It's in JP courts that I noticed the difference, and they just dismiss it. And in some ways I get it, but is it probably proper? Probably not, but it's what they do. And you know, you get your clients some extra time.
It's time for a break.
Yeah, let's go ahead and take, how long a break do y'all want to take? Lisa, you're the 5 minutes?
We're gonna take this one 5 minutes. The next time we might take 10 minutes. It gets
Okay.
harder the longer you go.
All right, let's do a 5-minute break.
Thanks, guys. Keep going.
All right, so we're back. I hope everybody enjoyed their break. So for the rest of the part of the notice to vacate, again, does it actually come from the landlord? And so like I said, one time I had a notice to vacate that it just listed the management company. And, I had nothing else, or I was trying to make the argument about the abatement. The judge wasn't going for it. And so then I went ahead and, like I said, I only do things piecemeal. Let me just make this argument. I'm like, well, judge, show me on here where it says that this is coming from this particular landlord versus anyone else. This notice to vacate that's required to come from the landlord, or that it even mentions anywhere the landlord's name for this. And after that, I think it was probably, Judge Stevens out in part of Harris County, and he went with it and said, okay, yeah, I agree. So I'm going to go ahead and dismiss the case. One thing just to note, for certain subsidized housing, they actually have to give a copy of the notice to vacate to the housing authority. And if they can't show to do that, then to me, there's two different arguments with that. You could potentially argue it's a condition precedent, but I think the better avenue is to just argue it's an element of the notice to vacate, because the notice to vacate even lists there unless there's other notices required by other law. And that is kind of part of it that I would just still argue that here, other law requires two notices to vacate, one to the tenant and one to the housing authority, the local housing authority. Yes, Lisa.
I was just going to say that Eric said it's the tenancy addendum to the HAP contract. It attaches by law to every Section 8 housing choice voucher, but no one is ever given a copy of it. I'm about to post a link to it, but understand that just because your client doesn't have it doesn't mean it doesn't apply. It attaches by law.
Yes, and it's explicitly enforceable by the tenant.
And this would be one of the things to remember that is a little bit different from justice court to county court, is the rules of evidence don't apply. And so when you can use them in your favor, use them in your favor. Get a copy of it, even if it's not official. And if you know it's a housing authority contract, get a HAP contract and say that this is attached to the tenants and it is part of it. Just don't worry about having the specific one to your tenant, because you might not have time to get the business records affidavit, to get out a subpoena, to do everything that you have to do. Even though in the past, I have before subpoenaed the actual housing authority reps to the JP court eviction when I felt, and oh wow, that one was interesting. I had it from Needville. I was the JP court, and it was in Galveston County was the housing authority. So that one was a little bit interesting, because they were the ones still doing that voucher, and they came because it was still within my 150-mile subpoena power. And so they were there, and they brought the official HAP contract, and they were able to do it. So if you have time to do that, great. If not, maybe make sure you have a copy of a HAP contract in your back pocket to throw down and say, you can just ask your tenant, are you part of Section 8? Yes. And is part of Section 8 having this addendum to your contracts? Yes. And, maybe the the JP judge, hopefully maybe they've been educated about that before, and if so, it can apply to you. This is one that it's worked one time for me. And so it's up to you if you want to try or not. But, the rules of civil procedure, they do allow for an agent to apply, to appear on behalf of a landlord. But, but to me, it's like when I'm looking at these eviction petitions, and this one's by Nationwide. So I'm guessing most people are probably familiar with Nationwide. But here it lists the agent as Eddie Dean Young, agent. So to me, sometimes Nationwide tries to act as if they're a firm of attorneys and send different attorneys in, but it doesn't say that the agent's Nationwide. It says that the agent is Eddie Dean Young. And so once I told Judge, well, who's this Maria person? Where's Eddie Dean Young? It says here on this petition that's the agent. That is the authorized agent according to their own petition. Who's this person? And one time the judge went for, or I think he reset the case to try to allow the other judge, but each reset, it's a win. Let's not split hairs here. A win for us may not be the same as winning a full judgment, but every time you can gain a little bit of extra time for your client to try to find somewhere else to go, that's a win.
Also,
Yes,
by the way, just an interesting thing. So we're doing right to counsel services here. I'm in our busiest court in Harris County, the precinct 4 place 1 every Monday, over 100 cases each docket, 2 dockets every Monday. And Nationwide has gotten so tired of me that they automatically reset all of their cases that I appear on that day. So just showing up matters.
Yeah, I'll say they did that again, and then they showed up the next time too. They tried to.
They don't know.
I would say like I was in another court and they did that too.
Yeah,
'Cause-
they've gotten pissed
They
at
said,
us.
well, what they said is that I want to get a lawyer, but then when they
Yeah.
showed back up, it was still Nationwide. I'm like, this is no different, but okay.
Yeah, they want the chance to get a lawyer, but if the client doesn't want to get a lawyer, then they just send Nationwide back.
Yeah, no, I've seen that before too. They have reset. So, I mean, because they don't know what to argue. They like when I've come up with these responses Nationwide, they don't, or these defenses or these issues with the pleadings, Nationwide doesn't know what to argue. They're not lawyers. And so go ahead and, make your arguments. Now, here's some other factors. We kind of covered some of these already, but anytime when you're taking a case in JP court, you're going to want to figure out, can the client pay the monthly payments into the registry of the court if they became due? Now, maybe in the past they couldn't, pay their rent initially, but now maybe they're back on their feet enough where they can, and they need that extra time. Well, naturally, you're going to advise your client that if they get an attorney, that it can result in extra attorney's fees. But other than that, the only thing that they are going to risk is extra rent. And so that's the trade-off. You can inform them and let them know. But if you're going to do that too, make sure that they'll qualify for a pauper's affidavit, or if you're representing them, that you're going to be able to qualify to fill out the legal aid certificate, file it for them and attach it. Otherwise, they could run into a problem where they will get ruled against for their pauper's affidavit or the statement of inability to pay. I'm sorry, I still utilize the old name, but the statement of inability to pay, they could be disqualified and then have to post a bond of the 2 months rent. So you might want to make sure that they'll qualify for that, and then decide. Each of us, we should be familiar with our courts. I think, like at least in Houston, we communicate about what works in different courts. We meet weekly about these things and what doesn't work, what different JP judges are going to do. And so figure out, is this one that I can argue better in JP court, or your county court judges too? Is this one better to wait for county court because I know that my client can pay rent into the registry? And if you postpone it to county court, you have that benefit of there's all that extra time. The landlord will have to wait an extra month and a half maybe to go ahead and give that new notice to vacate and to start over. Also, would this be something that the landlord will even be able to cure if appeal to county court? Will they or will they not? Like, for example, for the assumed name certificate, all they have to do is file an assumed name, right? That I can do it for a client in about 10 minutes. Give me the information, file it through SOS Direct, and I'll have your assumed name and have the certificate printed out in 10 minutes. That's not going to gain you a lot of time, except that the thing is like I said, some of these Nationwide people, they don't know what this is, and they don't know what to go back and communicate, to the client or what the court was looking for. And so find that out. If it's something like the notice to vacate, that's something that they can't cure. That has to be given prior to the eviction lawsuit being filed. So you're more comfortable waiting on that once you get to county court. And JP court, like I used to say this, it's a little bit of the wild, wild west. Remember, it's not a court of record. And so hearsay doesn't apply. Rules of evidence don't apply. So do what you can. Whatever you can think of. I mean, you can try it. The judge may or may not allow it. But I recall one time, or a couple of different cases. One time I had a client who slipped and fell on the ice during one of the winter storms a few years ago. And she wasn't able to work. Because she wasn't able to work, she wasn't able to pay her rent. But had the landlord iced properly all the stairwells, she wouldn't have fallen. And they knew this winter storm was coming. The landlord said that they knew they just decided not to get some salt from their sister property is what they testified to on the stand. So what my argument was, they caused their own damages because my client wasn't able to work because the landlord is the one who failed to maintain the property. Now, yes, would that normally work? Probably in county court? I don't know that it would. But I was in JP court, and did I request a jury trial on it? I sure did. And actually, I had a student that had done it, an intern, and we won the case. And, we won it on those grounds. And I now had a statement from what the landlords had, an admission for my client's personal injury lawyer to deal with, where I said, yep, this is what they said on the stand, that they were aware the freeze was coming. They just decided not to get any ice from one of their sister properties, even though they knew this. And so utilize it. Just like you see the landlords utilize it, you can too as an advocate. Naturally, you're always going to want to stay within the bounds of reason and of ethics. You're not going to lie. But if you can bend the rules to your will, do it. Be creative, be inventive. And so those are the factors to consider in JP court. And then I think, Eric, we are ready to move on to your presentation.
While you're getting set up, John asked a question about whether or not there's any case law on the unequivocal notice to vacate. And I think he's sort of also referring to 24005I, Eric's favorite. In the last outline that I have from Fred Fuchs from Trala and UT, I don't see any case law in that outline. And I also just checked on Westlaw and didn't see anything come up specifically to 24.005I. If anyone knows of case, and I was going to go back and check Fred's outline again. Also, if you're new at your organization and someone at your organization hasn't shared it with you yet, please ask them for it, because I reference it every week. It's so useful. I call it the Eviction Bible, and it's really, really useful. And also, I'm just going to make a request. The latest outline I have is 2019. If there's an updated version, please send me one.
Yes, it is the Bible, and it's amazing. Yeah,
we have a question. Where can we get this Eviction Bible?
Fred and Nelson don't mind being sent around, so I think that we can probably do it if necessary. But someone at your organization should have it.
I feel like Fred has posted it on the listserv again. I can send a request asking if it's okay that I post it. Okay, it looks like 2019 is the most recent version, but I'll just shoot Fred an email, and if so, I'll send it around or ask him to send it out.
So I have two presentations. I'm going to be going over basic trial skills, and
someone is saying, just to let you know, that he might have just put out a new one last week.
What?
I know, and we don't have it.
It's big news.
Where was the press release on this?
Like, we're doing this whole thing for y'all and no one gave us the new Bible. Come on, y'all. Like, Ryan gets paid in cookies, but I get paid in Fred Fuchs outlines. Okay. So, yeah, I'm doing two presentations. One is on basic trial skills. So we're talking about like questioning techniques and objections. And then I'm also going to do one on evidence. So the mechanics of evidence, both introducing it and objecting to it. So this is, some of you may be experienced trial lawyers and not need to hear any of this, and that's fine. I won't be offended if you decide to leave after a couple minutes. I will also won't be affected if won't be offended if anyone decides that what I'm saying is, well, not right. So feel free to comment. Okay, so we're going to start with the trial skills. And, you know, a lot of us have practiced mostly in JP court, and I'm not just talking about new lawyers. I'm talking about even some who have been out for a while. I know that it was a while before I practiced in a formal court setting. And so it's just a very different world. And these presentations were created in the world that was, where courts were were all in person. So some of the advice is, that the idea is that you're in court, but it's pretty easy to imagine how to do it over Zoom. Okay. Oh, sorry, give me a second. Okay. This is my super kitschy presentation that I made for my students, so you're going to have to forgive the slight ridiculousness of it. Okay, so let's talk about direct and cross-examination. Okay, so we're going to start with some general concepts, like what different kinds of examination are, the general guidelines for them, and then we're going to get into more specifics. So first, courtroom etiquette. This is actually applicable to a shocking number of us because some of us have only been to trial on Zoom in county courts. And so it's important to remember that when you do go back in person, you have to dress professionally up top and on bottom, not just the Zoom mullet. You address the judge as your honor or judge. You'd be surprised. You always stand when addressing the judge. That's true no matter what court you're in. If you are there in person, you stand up when you address the judge. This is in California. And if you're in real court, then don't enter the well without asking the judge's permission if you're conducting trial from the counsel tables, because you don't want to just approach the bench without asking the judge first. However, we all know that the vast majority of county court of law trials occur at the bench. So direct and cross, two different kinds of examination, right? The fundamental difference is one is your client, one is the opposing client. One is your witness, the other is the hostile witness. But the really important thing to understand is where the focus needs to be. So on direct, the focus needs to be on the witness, right? You are facilitating the witness telling their story. While on cross, you are the star. The focus needs to be on you. You are manipulating the person on the stand to tell your story. On direct, you do not want to lead. You want to ask questions that will not get objected to. Now, I want to make this caveat now. Something is only wrong if the other side objects to it. Now, that doesn't mean you have carte blanche to clown around, right? But if you get the sense that opposing counsel doesn't know what they're doing and is not going to object to things, lead all you want, right? Same thing with hearsay, right? It's only hearsay if they object to it as hearsay. And we'll get to that later. So, yeah. So when you're designing testimony, you want to have chapters that you divide things into so everyone can understand what you're trying to say. So first, you want to make an outline for how you want things to be presented. You want to start with the foundational questions on direct, right? Like state your name, who are you, why are you here, et cetera. And then you want to have the issues that you want to bring up separated over the course of the testimony. You also want to make sure that your transitions aren't too awkward. So, remember, testimony, someone's listening, right? And you don't want them to be jarred, but you also don't want them to go to sleep. So try and make sure when you go to one issue to the next, there's some reason that you're making that transition. Meanwhile, with cross, it's all about calling audibles. It's almost never going to go as planned. People have different theories on how to prepare for cross. Some people don't even make an outline. so much, or even write questions. That's a rarity. Some people prefer an outline to actual questions because it gets so wonky. It is entirely up to you how you want to operate. Donna, did you have something?
No, I'm good.
Okay. So yeah, also cross is heavily dependent on the direct examination of the.
Eric, why do you want to do it that way? Because I don't know that you
Objection,
should be.
Your Honor. Your Honor, objection. Miss Everett is speaking out of turn. It is my turn right now to be questioning the witness. And if Miss Everett has something that she'd like to ask or extrapolate, she can do it when it's her turn.
So fun little demonstration. In eviction trials, opposing counsel, I mean, trials in general, but especially in eviction trials, opposing counsel may just straight up interrupt you while you're doing questioning, in which case you need to stop them from doing that. And a cardinal rule of trial generally is to only address the judge or witnesses, not opposing counsel. So if opposing counsel does that, you don't look at him and say, excuse me, stop talking. You say, Judge, I'm trying to question the witness. Please instruct opposing counsel to refrain from interrupting me. But you do have to keep that under control because otherwise they're going to run all over you.
Now, I would also say with cross especially, or for me, my tactic is always avoid the really confrontational stuff until the very end of your cross. You know, if you're really going to be accusatory, if you're really good, and sometimes one of the strategies is get them to answering friendly questions. If you have a landlord, now, ma'am, you're the property manager, isn't that correct? Yes. And as part of your job as the property manager, it's your job to review all the leases? Yes. To make sure all the tenants are paying their rent? Correct. And to doing this, you know, get them to just go through it until you say, and you oversee all the notice to vacate. You're diligent when you do that, isn't that correct? Yes. You're going to make sure that you have everything you can prove, correct? Yes. And then get them to say yes. And until then, you're like, but you don't keep a picture of the notice to vacate you delivered to make sure. I mean, so you can get them to first answering questions they're not going to disagree with before you can go on the attack.
So,
And
we'll
so
cover that
I didn't
in
want to,
slides.
yeah, I didn't want to interrupt Ryan and object again that Eric and I here were leading our own witness, not leading our own witness, examining or cross-examining. But this issue has come up before with attorneys who are concerned about how often they can object, whether it's because the question is leading or if you've got hearsay objection, whatever kind of objection. And so kind of the general rule that I follow is I will object whenever I need to. I want and need to preserve the record. It may annoy the judge. And I think if you find that you're at a point where it's just about to throw the judge into a place where they hold you in contempt, maybe at that point you want to ask for a standing objection. But otherwise, part of your job in county court is to preserve the record so that you can go up on appeal if you need to.
And you need to make sure you request a record because it is not, sorry, Eric, go ahead.
No, it's fine. Yes, request a record. I'm just saying, like, this is a long presentation. More is coming, I promise. More fundamental things about direct and cross-examination are coming. So yeah, you want to listen to the testimony on direct and consider marrying the witness's testimony. We're going to talk about something called looping that involves that, but also try to avoid rabbit holes. One of the biggest problems that people have on cross-examination is going down rabbit holes, is trying to get someone to say something that they're never going to say, and just asking question after question after question, which is objectionable and also annoying. So if you aren't getting the answer that you want, you drop it and move on. Okay, so looping. Looping is using a word or phrase from a witness's testimony in questions subsequently. So if you have something that is it really pops, like a phrase that really pops, then you want to repeatedly use it over time to make sure that that phrase gets into the fact finder's memory. On cross, it's even better, because if they say something that is really bad, again, that's really bad for them, then you want to repeat that in your questions going forward, over and over. Okay. Let's talk about direct examination. All right. If you completely forget everything about your plan for direct examination, ask these questions. Who, what, when, where, why, and how. It'll get you back on track. It'll get you where you need to go. It's surprising how effective it is, because usually you ask those questions and you'll get a sense of where the next place you need to go is. So this is the basis. And it's also how you should lay the foundation for your witness, right? You want to ask these questions to establish who the witness is, why the witness is there. You don't have to ask a whole lot of them depending on the witness, but you do want to make sure that everyone knows why the witness is up there. So, rules of direct, no leading, right? And these rules, again, are the Dudley Do Right, saintly rules of direct and cross-examination, right? It's how you do it to avoid objection. That being said, again, if they're not objecting, sometimes you can just keep doing it. So, no leading, no assuming facts not in evidence. That means you don't want to ask a question that relies on a fact that has not, to which there has been no testimony, right? So it's, if you say, okay, this is a really silly and basic example, but if you say, okay, what's your name, Eric? Where do you work? Say, you could object to that as assuming facts not in evidence because they have not testified that they have a job, right? Obviously, it's a really stupid objection to make in that case. But keeping that in mind, you can't let people ask questions that assume facts that are not in evidence because it'll just get hit. You also don't want to ask completely open-ended questions because, one, you will not be able to control your witness. And that's even no matter how much you woodshed them. And woodshedding, for people who don't know that term, it's an actual legal term where you, to get your witness to behave, you take them out back to the woodshed and beat the crap out of them until they get it right. So you want to woodshed your witnesses first, but no matter how much you do, if you ask completely open-ended questions, they will screw things up for you. Always, if you need more, you should ask for limited amounts of information. You can always ask more questions if you need more information. Okay, so let's talk about looping on direct. So why do you want to loop on direct? Make sure the fact finder gets a key piece of information, right? So example, do you own a car? What makes it the car you own? What model is the Toyota you own? What color is the Toyota Camry you own? Is the red Toyota Camry the only car you own, etc.? If it's an important part of your case that they were driving a red Toyota Camry, then this will make sure that the fact finder, whether it be the judge or the jury, remembers that that was the case. And while that may seem insignificant in a vacuum, then driving a red Toyota Camry might be the key to the case. Okay, let's talk cross. Okay, number one rule in cross, lead, lead, lead. Do not hold back. You are the star of the show, okay? Now, once you get better at this, right, people who have been doing this for a while can be more comfortable with including open-ended questions in their cross. But to be safe, lead, lead, lead. Don't want to hear, have you ever been to California? You want to hear, you have been to California. So, cross questions. How do you want to design a cross question? The question contains the fact you are trying to get them to admit, right? Like you are from California. The question contains only one new fact at a time, not you moved here from California in 1996, right? You moved here from California in 1996. And it's a yes or no question. Again, I'm not even going to go over open-ended cross questions. They are difficult and they are a minefield. You will get better at this if you aren't already, and eventually it'll be okay. But for the beginning, at least when you're first starting out, it's a lot easier to just stick to leading questions. Okay, let's talk about constructive and destructive cross, which is what Ryan was talking about earlier. So constructive cross is designed to use an adverse witness to build your case. It's also designed to make the witness feel comfortable. Destructive cross is used to attack the opposition's witnesses and theory of the case. So usually you use what you established during constructive cross to engage in destructive cross. So remember that if you are trying to establish a fact, 100% of the time, it will be more convincing from the other side than it will be from your own witness, barring expert witnesses, etc. But if the fact is bad for their case, if you get them to admit it, the fact finder is going to like it more than if you just get your own witness to say it and they deny it. So getting an opposing witness to admit something that they might not want to is a good, constructive cross is a good way to do that. So the way you do it is the way that Ryan was talking about, right? You ask a series of innocuous questions. First, some innocuous questions about the witness. And then you start asking some questions that are difficult to deny, right? Like honesty is important in a relationship. It's good to follow the law, right? The best cross question, right? The best cross question is one to which there's no good answer for the witness. So in these cases, they may sense something coming, but what are they supposed to say? No. Then you get to destructive, which is more traditional cross-examination, right? And it attacks the witness. It is not always a good idea to attack the witness. Everyone has different cross styles, and you don't have to be flamboyant. You don't have to be angry. Some of the best attorneys that I have ever seen never raise their voice during cross and are absolutely the most effective. And that doesn't mean it's the only way to do it, right? But destructive cross doesn't have to be flamboyant. If you overuse it, the finder of fact is not going to be happy with you, right? Because it's going to feel like you're just abusing the witness rather than trying to get anything useful out of them. And there's always a difference in strategy between judge trials and jury trials. Judges obviously have more tolerance than juries might, because juries are easier to alienate on facts. But okay, so, and let's talk about looping on cross. I know this isn't exciting as Ryan's presentation, but hopefully y'all won't fall asleep. So looping on cross is a great way to emphasize a given piece of information. You can either loop with something they said on direct or with something they say to you on cross. So on direct, they testified that they were a good mother, right? You testified that you were a good mother. A good mother is responsible. A good mother takes care of her children. A good mother is there for them when they need her, right? This is constructive cross. Your son went to the hospital last year. Your son needed his good mother at the hospital. Yes, but you weren't at the hospital with your son. You were in jail. So there's the destructive. And you again want to loop in jail, in jail, in jail for drunk driving. So this really hammers things home for the fact finder. And then the mic drop, and yet you consider yourself a good mother. And the mic drop is important because you don't want to ask one too many questions. Sometimes this question is one too many, and it's difficult to learn where that one too many is. But once you've made your point, stop. If you have gotten the information that you need, stop. Because otherwise you are going to hurt your case. Just drop the mic. Indeed, questions in the negative bring answers in the negative. And a double negative is indeed confusing. It's also important to remember yeah, I mean, I certainly see both ways, right? Okay. Sorry. Okay, managing runaway witnesses. So on cross, the witness obviously will sometimes not be happy with the way things are going. And so there are countless ways to deal with witnesses who will not stop talking, not stop answering questions you didn't ask, right? Talk to the hand is a good one, right? Sometimes you can physically stop someone from doing that. Not as easy on Zoom, as it turns out, but in the courtroom, sometimes you can. But the safest way to do it is to make a non-responsive objection. If you ask a question and the witness says something that you did not ask for, so a yes and or a no but is usually how it happens, right? Then if they do that, you object as non-responsive because you didn't ask them that question. What's important is, especially in a jury trial, you want to move to strike whatever they said that was non-responsive. Otherwise, it stays in the record. So objection, non-responsive, judge makes a ruling, sustained, and then move to strike the specific words that were said that were non-responsive. You don't want to strike everything necessarily, but you want to make sure you target it. Okay, stock objections. Some stuff in chat. Indeed. Okay, so let's talk objections. How to object? Again, in real court, stand up. Standing up is very important because immediately it will stop things, right? At least it should. If you stand up, they know something's happening. You want to make a legal objection. We're going to talk about legal objections, but you don't want to stand up and say, objection, Your Honor, I don't like what's going on, right? You don't want to make a talking objection. There are specific objections that can be made in court, and you want to make one of them, not something that is outside the scope of what's accepted in trial practice. Opposing counsel may try, right? In which case you say, Your Honor, that's not a legal objection. Don't elaborate on your objection, right? Sometimes with some objections, it is specifically appropriate to elaborate on your objection, like a foundation objection. But don't just start talking. If they want more information about your objection, then they can ask you for it.
Eric, there's a question in the Q&A.
It's generally enough to get the court's order in the record. I've never had to ask for a written signed order on a motion to strike. But if anyone disagrees, I'm definitely happy to entertain that disagreement. All right. Also with objections, always get a ruling, okay? Don't let trial just continue without a ruling. It should be sustained or overruled. So if the judge may say, no, I think it's okay. You say, can I get a ruling, Your Honor? Because it needs to be preserved for the record, right?
There's another question in the chat, Eric, about, can you discuss how you control your own runaway witness?
Well, the best way to do that is to woodshed them, right? However, as someone—
Can't do that in court, though.
Well, to prepare, right? The number one rule for trial is preparing. However, I represented 20 people in court on the spot on Monday. And so I understand that that's not always a possibility. And the one thing that you shouldn't do is go like this, even though that will be the tempting response. But you just, normally sometimes you just put a hand right in front of them or say, it's okay, okay. We'll have our turn. It can be difficult because these are such high emotion cases. It is completely understandable that the witness will have outbursts. It's always important to tell the witness, no outbursts, only speak when spoken to. Do not talk unless you are asked questions. Do not give information unless you are specifically asked for the information. Sometimes it works.
I once watched a family law demo in which this happened, and the attorney objected to their own witness for being non-responsive.
Yes, I've done that.
I think saying objection and having the judge talk can also help slow things down. And then before you start, you can say, remember, client, please answer the question I'm asking.
Yes. Look, I've been there. I've had to object as non-responsive to my own witness. And, you know, you don't want to look like an asshole, right? You don't want to look like an idiot, but sometimes you have to, because it's better. Yeah, Brian.
And I would just reiterate the importance of what you said, Eric, about making sure you get a ruling. A lot of times, some judges can be a little intimidating, but you have to remember that as an advocate, you're the last line of defense for your client. And if you don't get that ruling on appeal, any issue you had with that objection will be waived if you don't insist on a ruling. And so sometimes the judge will say, move along, counsel. That's not sufficient, all right? Even if you've made a proper objection and they tell the other attorney to move along, nothing has been sustained, and so nothing has been stricken, and so that evidence is still in. And that's very typical. What I see is sometimes judges will just say, move along, and the attorney will move along.
Yeah, and the judge will understand if you ask for a ruling, right? There's a reason they didn't do it, right? They just didn't want to bother with, but they don't mind giving a ruling. They understand that you need that for the record. Also, never think or argue with the judge, right? That won't get you anywhere. There's a difference between discussing things with the judge and arguing with the judge. You can continue to press your case if appropriate, but once the judge has ruled, you stop. And don't thank the judge, because it's just not classy and will make you look silly. All right. Okay. So objections on direct. Okay. So this is objection. These are objections you would make when the other party is on direct. So number one, leading. Okay. They cannot give the witness the answer in their question. That is not allowed on direct. Cross, yeah. On direct, no. Also, you'd be surprised how often this happens, but watch opposing counsel, because sometimes they will be asking questions and nodding. Usually it's not on purpose, right? All of us have felt ourselves doing that, but that's leading, right? If you are asking basically a yes or no question and you're nodding yes, that's leading. You need to make that objection. But most of all, listen to their questions. And if they are giving the fundamental thing about leading is they are giving their witness the answer, you need to stop them from doing that. Now, it's okay on foundational questions, like you can ask like the who, what, when, where, why, the stuff like that are just establishing the basics about the witness. Don't object as leading. You don't want to piss off the judge by objecting to stupid stuff. But if what they do affects the case, then it needs to be objected to, period. Calls for narrative is another one. Either calls for narrative or unduly narrative. So you don't want to let opposing party just say, tell your story, right? They need to ask questions to get specific information. That's a legal objection that's not going to fly. Now, if they ask a question and the witness just goes on and on, then you can object as unduly narrative. But either way, you don't want that to happen, because remember, the star on direct is the witness. So you want to make the lawyer work for their money. And so no narratives. Assumes facts, not evidence. We talked about that briefly earlier. This is a way for lawyers to get things they might not easily get into evidence without actually having to do it. So if you ask a question that assumes something is true, even though that thing has not been testified to yet, and they answer and you get it on the record, then you essentially incorporate that in as true. You want to listen to questions and make sure they don't do that. because that can be very sneaky. Also, counsel is testifying. That one's pretty self-explanatory. Don't let the lawyer just testify unless it's to attorney's fees. Okay, objections on cross. So these are objections that you make when the opposing party is on, when the opposing lawyer is on cross, right? So beyond the scope. Technically, in real trials, you can't cross people on stuff that weren't, that you generally can't cross people on stuff that wasn't mentioned in direct, right? Now that whether it was mentioned in direct gets complicated, right? Like whether they open doors. But if it's something that was completely left out of your direct examination, likely on purpose, and they try and cross them on that, you need to object as beyond the scope. Argumentative, badgering, both of them are, badgering is generally a repeated line of questioning that is what it's, it's kind of, I know it when I see it. Argumentative is a single question generally that is in itself makes an argument, as it says, right? In itself makes the argument rather than leaving it up to the witness. Both of those are, I know it when I see it, objections. They're a little more difficult than some of the others that are more clear cut. And privilege is also obvious. If they ask for information that is privileged, then you need to object. Otherwise, it gets in. And obviously on that one, if they answer, you need to move to strike the testimony as well. Okay. Stuff on both direct and cross. So relevance, right? You can't just ask them questions about anything, right? You need to ask them questions that are relevant to what's going on. And if they start trying to ask about something that might be, especially something that might be harmful, but really is tangential to the case, then you need to make that relevance objection. Calls for speculation, right? Fundamentally, the answer to the question has to be given with actual knowledge of it, not speculation, not hearsay, right? This is the fundamentals of questions and answers in court, that the answer has to be given from knowledge. And so speculation then is not good enough, right? If you're asking what they think may happen, then that's not going to be good. Hearsay, hopefully we all know what is, right? An out-of-court statement made for the to establish the truth of the matter asserted. Asked and answered, so especially on cross, right? Especially when they're on cross. You don't want to let them keep asking the question over and over again because they don't like the answer. So people will. When they don't like the answer, they'll just keep rephrasing the question. And that's not okay. You need to object as asked and answered and get them moving on. Misstatement of the record.
Objection. I'm going to pause. And the reason for the never mind, no objection. So the reason for this objection was only to throw off the examining attorney who's gotten into their routine, and we want to trip him up. This is not in the rules. I don't recommend it unless you really feel like you're about to win your case on a wonderful argument and you want to try this kind of for the first time. But at some point, you'll feel like the questions are going on in a way that's not helpful to your case, and you just want to frustrate your opposing counsel. So you object to something that you can later withdraw. I withdraw my objection. Carry on.
You get one. Okay. You get one.
And I say usually you do have a valid objection.
Yeah,
because you're not supposed to object if you don't have a valid one, but maybe one that isn't all that important, or there might be an exception to, but you should have a valid objection. Then, like Donna said, Judge, I withdraw it and sit back down.
Yeah. Do not underestimate the power of interrupting opposing counsel's flow with an objection.
I just want to remind everyone of hearsay within hearsay. And I think that this is especially important when they're bringing in things from the tenant's record where another neighbor complained about something. Well, the fact that they made the record, I'm fine with, but I am not okay with the neighbor's statement.
Yeah, definitely. You want to make sure that you examine for hearsay at every level. Like if it's a document, we'll talk about documentary stuff in the next one, but you're going to want to make sure that you examine not only the document itself, but everything in the document. Lisa's exactly right. Misstatement of the record, if counsel in the question misstates what has been said, then you make that objection. And finally, compound. So I talked earlier when we talked about cross questions that you should only have one fact at a time. That's required. So if you ask two questions in one, you should object to that as compound. You should always do it, because compound is a great way to screw up someone's flow, because it's a perfectly valid objection, even though it might not really matter. So okay. So a brief note on bench versus jury trials. Most of this is pretty intuitive stuff, right? The difference are the way you need to control the flow of information, the sophistication of the fact finder, right? And how they'll interpret what you're doing. So your style in court, judges are used to, rash attorneys are used to basically anything that an attorney can throw at them. But it's much easier to alienate a jury if you're not careful with by being mean, let's just put it that way, or by being soporific. The judge, however, is at least trained to pay attention and disregard some of the fluffier elements of this. Do y'all have anything to add about bench and jury trials?
Well, definitely I'd say, for bench trials, you don't have to worry about being as colorful. You don't have to worry about being as engaging or as entertaining as you do for perhaps a jury trial. You're going to have to make sure that you're really on point. And you have to remember that the jury, just like all of us nowadays, has a very limited attention span. And so if you're going to make it too complex as well, that will even wear away their attention span quicker. So you're going to make it even more simple if it's a jury trial than it will be for a bench trial.
Do either one of you have any comments or suggestions? Because the judges are used to developing the case because they're used to pro se litigants, even at county court at law. When the judge is developing the case and they're doing it incorrectly, or I mean, just not offending the judge, but maybe getting the judge, like letting you develop your own case.
I'm a little confused what you mean.
I just didn't know, like, if sometimes the judge will take over answering questions, like you're in opening statements and they start questioning witnesses.
Mhm.
Do you say anything? Do you say anything or do anything, or do you let them go?
It's a case-by-case basis, normally I'll let it go unless I feel that it's directly going to interfere with the presentation of my case.
I also just want to comment that it's 3:02. We said we would take another break.
Oh, good. Yeah,
And because we were kind of at a stopping point, I'd like to suggest that now. So I said 10 minutes, let's do 8 minutes and come back at 3:10. See y'all in 8 minutes. Bye, guys.
Eric, it's still recording. I don't know if you wanted to pause it during the break.
Okay, so that was the end of that presentation. So good timing. Now we're going to go on to evidence. All right, we're going to talk about introduction of and objecting to evidence. So as we all know, there are two levels of eviction courts, the JP court and the county court at law. Calling JP court kangaroo court, I think, is charitable sometimes. Obviously, it varies by judge, but I did include a small kangaroo in the county court at law because, let's be honest, it's still not quite what we would expect from a formal courtroom sometimes. So in JP court, there are no rules of evidence. So you can do kind of whatever you want. Now, that doesn't mean that the way I look at JP courts is that even though the rules aren't there, all of the reasons for the rules still exist. So you can make the arguments basically in equity. Like you say, look, I know there's no hearsay rule here, but Your Honor, this is not trustworthy. You know, this is an out-of-court statement. There's no personal knowledge here. And they can still say, okay, I agree with that. It just goes to weight. It's not admissibility. So don't be afraid to make those arguments in JP court, but just don't call it hearsay, because especially with the JPs who aren't lawyers. So meanwhile, county court of law does follow the Texas rules of evidence.
I'm just going to point out that I have had JPs allow the rules of evidence to be followed if the other side is also represented by counsel, and they're
Yes.
normally not prepared for that.
Yes, again, it's JP by JP, but lawyer JPs, we have one here who is a lawyer and who has a special attorney docket. And so attorney docket looks very different from the other dockets he has. It's smaller and it's more formal. So while I wouldn't necessarily say that the rules of evidence are fully honored, it certainly would not be out of place to make an objection like that and ask the judge to formally take it into consideration. But yeah, the JP does theoretically have the right to do kind of whatever they want in their little fiefdom. So I think that's kind of why people become JPs sometimes. All right. So prerequisites to admissibility. There are certain things that evidence has to be in order to be admissible. First is relevant. Okay. So there's Rule 401. It's very explicit. Having any tendency to make the existence of any fact that is of consequence, you can read. So you definitely have to make sure that whatever you're entering is relevant to the specific dispute that you're having, right? And so that may hinge on the grounds for eviction that have been stated in the petition. So that's a big one, because landlords love to talk about tenants' bad behavior when the only grounds that they've given for eviction are non-payment of rent. So any kind of pictures of the apartment being messy or anything like that, that objection is not, that evidence is not going to be relevant to whether they paid their rent. And so you want to make sure that anything you put in is relevant and anything they try to put in is relevant. Authenticity. So we're going to talk about authenticating. So you have to make sure that the person who through whom you're getting the evidence in can ensure the court that it is what you're saying it is. Hearsay. Okay, can't be hearsay. So hopefully everyone took evidence, right? Everyone knows a little bit about evidence, knows enough to know what hearsay is. Obviously, whether something is hearsay is way more complicated than just this definition, and we'll talk about it more, but it can't be hearsay. Originality. not as big of a deal for most of our evidence, but still applicable. And then unfair prejudice, right? That's the like relevance. It's the other sort of soft prerequisite that you need to have. You need to, even if it's relevant, if it's unfairly prejudicial, then it needs to stay out. And there are certainly some things that you could argue in landlord-tenant practice that are unfairly prejudicial. And some photos or videos or documents that just they're so prejudicial that they do not merit admission. So I would say yes if there's no business records affidavit. If you want to object to the notice to vacate as hearsay, that is your right. But just objecting to the actual document is not necessarily going to save you, right? But yeah, you could. Mostly, you would only do that if, to me, I would normally only do that if there's hearsay within hearsay, like Lisa was talking about, right? So if the notice to vacate contains a statement that is itself hearsay, then I would definitely consider objecting to the notice to vacate. But they don't necessarily need to have the notice to vacate in the record to establish that a notice to vacate was delivered properly. So yeah.
Sorry, I just want to push back a little bit and maybe tweak the question a little bit. If they're testifying, like, how was the notice to vacate delivered? Like, if the question is, how was the notice to vacate delivered? It was put on the inside of the door. If they weren't the one who did that, they don't know.
That's different, right? You object to that as lack of personal knowledge. So without question, but whether the notice to vacate itself is in the record is not what defeats that. It's the fact that they are testifying to things to which they have no personal knowledge.
Also, it's worth asking your client beforehand, like, who is the person who delivered it? Or maybe there's even someone's signature on the bottom. There's a lot of turnover at apartment complexes.
Yeah.
And some of these cases are being spaced out. They don't have the same staff they had.
Yep.
And it's worth asking, like, do you know if the people in the office are the same people there at the time you got this? Because sometimes you have all hearsay issues.
Yeah, for sure. And so not only that, they may not know that, but ask them to take a look at the person who has showed up to court and say, do you know that person? Is that person who delivered the notice, who did this? And if they say, I don't know who that is, or the person who delivered it used to work there, but that's the new manager, then they're going to have problems. So definitely what we're talking about, the objecting to the lack of personal knowledge on testimony about notice to vacate is a classic way to win at county court of law, without question. But the paper notice to vacate is not as big a deal unless, for instance, it contains an assertion that the notice to vacate was delivered in a certain way, right? Because that would be hearsay within hearsay, and that would be worth objecting to potentially. Okay. Now we're going to talk about the mechanics of introducing evidence. There are 4 steps when you're trying to get an exhibit admitted. Mark, identify, authenticate, offer. So we'll start with mark. When you are in county court at law, you want to make sure you mark every exhibit. You want to look at the local rules of the court to see if they specify whether they want numbers or letters. Sometimes they do. And you want to make sure you give a number or a letter depending. So sometimes they don't bother to tell you that until you get to court and they say, oh, in this court we use numbers, but nothing you can do about that. So put a sticker on there, or in a pinch, just write petitioner's exhibit 1 on there, or, that not petitioner's exhibit, a defense exhibit 1 on there, and that'll do in a pinch. So you got to mark it first. Then identify. Okay. So again, this is in the world it was, right? This is the language that you want to use to make sure that you don't screw it up. Your Honor, the second one is the big one. Your Honor, I am handing the witness what has been marked for identification as petitioner's exhibit X. Okay, you don't want to say I am handing the witness petitioner's exhibit X because it has not been admitted as petitioner's exhibit X. It has only been marked for identification as petitioner's exhibit X. Again, replace petitioner with defendant. And you may get in trouble with the judge if you assume otherwise. And of course, a copy should have already been furnished to the opposing counsel if you're doing this right. Okay. Authenticate. You need to make sure that you ask enough questions to convince the court that the person you are trying to get this in through knows what it is and can testify that it is what you're saying it is. So the trick here is to do it without asking about the substantive contents of the exhibit, right? Because if they do that, then you have to object as the witness testifying to the contents of an exhibit not yet admitted. And so opposing counsel should do that to you if you do it. So if you've got a photo, for instance, you can ask general questions about the photo. Who took it? What's it of? When was it taken? Where was it taken? Why was it taken? And how was it taken? All of those are acceptable questions about the photo, right? But what is it a photo of is possibly not. Additionally, say with an email, right, you can ask about who sent it, to whom, when it was sent, why it was sent, possibly, and how it was sent. But you can't ask about what the email says because it's not in the record. So you have to authenticate it by asking questions of the witness that will establish its authenticity without violating the rules. Now, again, you only violate the rules if they object. So can you lead when you're doing this? If they don't object, can you ask them about the exhibit, the contents of the exhibit without actually entering into evidence? If they don't object, but you want to read the room, okay? Sorry, that's supposed to be OC. Opposing counsel may not intend to object to the exhibit, right? If you get the sense that there's not going to be a problem entering this, if you haven't already, you can obviously stipulate things pre-trial, but in evictions, you don't always get to do that. And so you don't want to ask 8 questions to lay a predicate. You're going to annoy the judge because you're asking endless questions for something that very obviously is not going to be a problem. So a basic 3-question predicate may suffice. Do you recognize this document? What is this document? Is this a true and accurate copy of this document? Has it been altered in any way? No. Okay. Then Your Honor, I move to admit this evidence as petitioners or as defense exhibit X. All right. Again, magic words. Okay. I move to admit is a motion to admit this evidence as petitioners as defense exhibit X. So magic words will make sure that you get it right every time. So objections to evidence. Big one is lack of foundation. Okay, this means they didn't authenticate. So if they did not properly lay the foundation for the authentication of the evidence, then you want to make that objection. Unlike most objections, a foundation objection requires you to explain why you're making the objection. So if you say objection, lack of foundation, you need to say there's no evidence that the person who testified actually took the picture, as they said, or no evidence that the person who testified actually sent the email, whatever it is. It can be anything, any part of the authentication you can object to. You only want to get really granular if you really want to keep something out, but you can make them go all the way, at least if the judge allows it. They may overrule your objection, but it has to be made with specificity. So let's talk hearsay. Not everything's hearsay, right? Prior statement by a witness, admission by a party opponent, and some stuff from depositions. It's all in the rules. I don't want to go that granular. You can always just read the rules. But recognizing what's non-hearsay is an important thing to do, because remember, this is not just you objecting. You have to defend against hearsay objections as well. Then exceptions, right? Again, there are a ton of them in the 803. Most of them are not that relevant to landlord-tenant. But business records sure are. And sometimes a recorded recollection recollection is a great way to get a police report in, or at least the content of a police report, without having to deal with hearsay. But the other one is statement against interest is the other big one that you're going to use. If it's something that the person said that might normally be hearsay, but it is against interest for them to have having said it, then it's considered a hearsay exception. So do y'all want to talk any more about hearsay?
Well, I think the one thing that we always cover that Lisa was going to mention is, or at one point is, this is the part that you have to also worry about double hearsay or hearsay within hearsay. Because, for example, the recorded recollection, if it in itself has hearsay within it, then you can still object to the hearsay within the recorded recollection. You would need an exception for each level of hearsay. So I think it's important for people to realize that, because sometimes people will see a business records, for example, and they'll think that anything in there comes in. Well, no, if there's hearsay within it, then that might not come in, as well as there's also, it has to be, the veracity of it should not be questioned either. And people forget about that. I mean, one example I had was for a grounds eviction. My tenant was in a dispute with one particular office worker. Well, that one particular office worker, and is the one who wrote up the incident report. Well, that might be a business record because it's kept in the normal course of business, but at the same time, its veracity is questionable because you have a dispute between two people. One is writing down what happened and trying to get it in as a business record. It's like, okay, me and Lisa got into an argument. I get to write down what happened, my story of it, and it comes in. No, that to me, so you have to be sure to look out for those things that you can still object to.
For sure. You got to look at every single part of every single thing to make sure that none of it is hearsay. Because even if you do get something in, that doesn't mean that every part of it gets in. As we've said, as was the example we gave of the notice to vacate with the statement of how it was delivered. Okay, so if the judge refuses to admit evidence you attempt to offer, right, you should preserve your attempt for appeal if you think it's worth it by making an offer of proof. So this is pretty standard stuff. It's basically, right, just making your argument for the record outside of what is going to count for the trial at hand. And if there's a jury, it's going to be conducted outside the presence, but obviously it cannot be conducted outside the presence of the judge. So, all right, business records. Ryan, you want to talk about business records for a while?
Well, yeah, I can just talk about them. So you have to realize for business records, it has to be made at or near the time of the event with someone with knowledge of the event, and it has to be a record that's conducted in the regular course of the business, okay? And you also have to remember that it has to be from the custodian of records. To be honest, anybody can be a custodian of records. Normally, they could be done through a business records affidavit, but if not, you can actually have the actual a custodian of records appear in court. And so like the example I had given earlier, like during my presentation, is one time I needed some records from the housing authority because it was back when JP courts did use the rules of evidence. And so I needed that actual record in there. Otherwise it could be considered hearsay. So I actually subpoenaed because there was not time, or they refused, actually, to be honest. The housing authority refused to give me a business records affidavit for the records I was requesting. So I actually had to subpoena someone, whoever they wanted to designate as the custodian of records, to come to court to testify, as well as the actual caseworker that had actual knowledge of his thing. And so of my client's file, housing file. And so just like I said, also it has to be, the truthfulness should not be questioned for these business records. And that's similar to the example I just gave. So you have, if it's something that seems that it's in the preparation of just simply for litigation, then it's really not a business record as well. I mean, so look out for those things for business records. Don't worry about it. The rule is the 14 days ahead of trial, or on discretion of the judge. It used to be pretty a hard and fast rule. It had to be at least 14 days, but now it has changed to where it can be also on discretion of the judge. And I think for these eviction trials, likely they're going to let them in, even if it's not 14 days before.
Yeah. Okay, so that's what I've got on evidence, and that's what we've got for this afternoon. If we want to have a Q&A session for the rest of the time, or if y'all just want to bail, either way is fine. But thanks for coming. And once it should automatically send you a copy of the presentation, I think. And this is my first time using this particular function of Zoom. So if it doesn't, then we'll work on making sure it happens. And if it doesn't, send the text of the chat, and it does send it to us, we'll send it out to everybody who registered.
Ryan, one of the big questions was, can I get your PowerPoint? And I know you're charging for it, but I'm sending it out. Eric said that he didn't think the Prezi would be so useful, so I wasn't going to send that. I think there's a lot of useful content in there, Eric, though. I really do.
Well, I'm happy to send it out. I don't. That's fine. I don't mind. It's just that it's more demonstrative than, informational. So, but I'm happy to send it out.
Can you print slides from Prezi like you can in
No,
PowerPoint? Okay,
not really.
got it. I was going to say, no one brought up like we're still doing trials by Zoom in Harris County for county court at law, and I just want to mention sometimes there's people off to the side. They may or may not be testifying, but if they're not sworn at the beginning, then I'm going to object that I didn't get, or that I didn't know they were there. They weren't sworn in, and I didn't get to invoke the rule if I didn't know. You know what I mean? Because otherwise they should have been sworn in at the beginning. I don't know how the courts are managing when the rule's been invoked. I haven't had that issue come up, to be quite honest, the past year and a half or so. The Fred's Bible was already sent out to the listserv. He supplied it while Eric was talking.
Perfect. And the other thing that we would just make sure to suggest to people is for county court, once you get there, remember the rules of evidence and the rules of civil procedure do apply. And as Eric's presentation demonstrated, at times you will need the proper paperwork or the proper party. And so that might require you to request maybe a continuance in the county court, depending on how quickly that trial is there. Because when you think about the normal timelines for discovery, you usually have to have all discovery like 60 days out if you're sending discovery to the other side to turn over to you, and it could and so you might be outside already by the time you get your notice of trial setting or what court you're assigned to. You might already be outside the discovery timelines. So don't be afraid to file a motion for an expedited discovery timeline. I also recommend, though, if you're going to do that in county court, to already have your discovery drafted and have already contacted the landlord to see if they would be willing to respond to some discovery, or your discovery before you file that motion. But you do definitely want to do that in county court, as well as if you need a continuance. And my argument is if there's an actual payment of rent into the registry, then there should be less, or there should be a less stringent deadline as far as the continuance goes. Also, if you're in county court, don't forget if you need a jury trial, especially if it's something that's not a non-payment of rent. I know a lot of times we focus on that, but if it's not one, you might want to make sure you file a request for a jury trial, because what I find is a lot of times, it depends on each county courts, but they're just used to seeing the landlords there every day than they are for your tenant. And so generally they're a little bit more receptive to the landlord's point of view on these things versus a jury. And there's a lot more things that may not come in through a jury that a judge will get to hear both things, even when they're trying to determine admissibility. And let's just be honest, once the bell's been rung, you can't unring the bell. You just can't. I mean, I recall one time I called a person to the stand and even just asked him, "Isn't it true, sir, you've been convicted of murder?" He answered yes. Okay. And yes, was it a little bit outside the timeline? It was. But what did the judge do? All of a sudden, her demeanor totally changed to him. It was like, before she was so accommodating, and after that, "Sir, do not take a tone with me. Do not do that. How dare you? If you need to talk to your attorney, fine. We'll all take a break so you can talk to your attorney. And sir, you can talk to your attorney too. You can talk to Mr. Marquez too while we take this break, because he needs to talk to his attorney." And then she withheld on ruling on his eviction for, I want to say, like a month before she issued a ruling. She took it under advisement and held it for like a month before she made a ruling. So those are all things that you can you should make sure. And don't be afraid to be a little colorful. Come on. I mean, life is short. You can try to ask for something. The worst that can happen is you get told no. And don't be intimidated from these judges. I mean, you get yelled at. And we get yelled at all the time. I mean, it's really not a bother. I mean, the main thing is you have to make sure whatever you need for your record is posted. And judges will try to trip you up so you don't have your record, so you're afraid to object and you're afraid to say these things. Do it anyway. Do it anyway. Now, my limit is, once I'm starting to see, a Mr. Marquez step back or a Mr. Marquez this, now we're getting closer to that line of contempt, and maybe unless really necessary, I might not go to jail unless I really think it's necessary for one of my things. But that was probably the limit.
One of the things that we were discussing before the presentation was resources that we might use for these objections and things. Most of our organizations probably have the Texas Family Law Toolkit. If your organization has it, you're not supposed to copy it, but maybe you want to look at it. It has selected predicates. It has common objections. It has objections. It's a really great, there's I don't know, 5 or 6 pages of it that I think are a really, really great cheat sheet if you're looking for one. If anyone else has other suggestions for that, and just, the Family Law Toolkit is something you get if you go to Advanced Family Law. I don't go to Advanced Family Law, but I've looked at one of my coworkers.
And we just have some things in chat that we should make sure to have the paperwork for a PR bond on file. But what I have even better, I have students, and my viewpoint is, well, it's okay that my viewpoint is I should be allowed to send a live body in my stead. Judge, Mr. Smith will go in my stead. And then once I run out of students, I'm out. It's as simple as that. That's why you try to take 2 or 3 with you to each court setting, or an intern or anything like that.
I hadn't thought about that. I need to take my students to court more often then.
And thanks for, Melissa also said you get the Family Law Toolkit if you join the Family Law section of the State Bar. So maybe I don't know how you get it because I'm not a member of that, but honestly, most of it I never, ever, ever look at, but those pages are amazing. I was also just going to mention, when you're talking, one of the other things, Eric, you were talking about how to object. You didn't even bring up timely filing. We have people that file things the day before they were sent notice they were supposed to file it earlier than that. That can be another objection. It's that it wasn't timely filed. You don't have to get into the merits of whether they can authenticate it or anything like that.
Oh, and a little practice tip. Now that you talk about timely filing, anytime I know I have not filed something timely, I go ahead in my motion or in my whatever, I go ahead and put a little section. If this is untimely, I request motion for leave for the court to consider and accept this outside the timely filing. Trust me, I've done that plenty of times. that way, when I'm within the 7 days and maybe I need to file an answer or whatever, because we get these cases last minute sometimes, and we're beyond sometimes all the timeliness requirements. And so I request leave for you to accept it, Judge. That way, I've already put that in there, and sometimes I'll include an order, sometimes not, because it's better just not to bring it to their attention. But I'll at least put that motion in there, so at least I've requested it.
Miranda's posted some predicate guidelines from Texas Young Lawyers Association. Thank you, Miranda. If anyone else has other questions or any situations that I bounce things off these guys all the time. They're all super helpful. And Stormy too. I know she was participating as a participant, but she also provides feedback to all of us. I know that we've said it before, but we're part of the Eviction Defense Coalition, and it's South Texas College of Law, University of Houston Law Center, the Earl Carl Institute, Lone Star Legal Aid, and Houston Volunteer Lawyers. And it's been such an incredible resource for the cases and judges and everything in our area, because some of it is somewhat specific.
Yeah.
And there's an evidence guide. Thanks, Miranda. I'm too old to be in that, so I don't know these things. Actually, I think they changed the rules, but whatever.
Yeah, I aged out. I don't want
That's
to talk
exactly what I was asking for though earlier today. So that's great.
about it. Yeah, I really can't overstate the value of engaging with the other organizations in your community. Having the Eviction Defense Coalition here has been the sole reason we have been so successful in mitigating eviction in Harris County. The sole reason we have a shockingly effective right to counsel program here in Harris County. We would never have been able to do it on, any of us would never even thought to do it on our own. And
now I think officially we have all the JP courts covered, right?
we do, yeah.
So there's always at least a legal aid person in the courtroom or available for anybody who wants assistance, I think, in all 16 of the JP courts in Harris County. So,
Yeah.
it's a lot of work.
And the county courts as well.
Yeah, HVL has taken the county courts, and it sounds ridiculous, but I was very proud on Monday. There were 220 cases in Precinct 4, Place 1 over the course of the day, and thanks to the coalition, there is a 10% representation rate of all cases set for trial. That's not cases that went to trial, all cases set for trial, and that's just massive. It's just massive. So, that. I really can't overstate how big a difference this has made. Also, the judges have responded, as Ryan was talking about. The judges have become educated. The judges have started doing things differently, and nationwide has started doing things differently. So, it matters.
Farwell, the name of the coalition is the Eviction Defense Coalition. We just kind of gave ourselves that moniker as we had weekly meetings. So we just
we're doing a fun run.
We've definitely made it harder for plaintiffs' counsel. Now they have to work a little bit harder to prove their cases, and I think our presence has made a big difference. And I think recently, at least in Harris County, and we just talked about this as a coalition, we're starting to, at least I was pleasantly surprised when opposing counsel kind of saw our side and just agreed, and we didn't have to argue about it, and case was abated. I'm starting to see that just a little tiny bit more than we used to. But that being said, we're still going head to head on a lot of stuff.
I also just wanted to bring up something else. Our judges are getting used to making records confidential. I am asking for in cases that do not fall under any of the emergency orders, and the judges are signing and doing it. And I don't know, Nelson Mock once said that in some of his settlement agreements, he'll request the record to expunge the record and whatnot. And I asked, how do you actually do this? And he goes, there's no way. Well, we're making the records confidential, and because the judges are used to it, start asking for it. And I'm not getting tons of pushback from opposing counsel either, especially if they want the stuff to be confidential. Then it's a really great, comeback of, well, in order to make it really confidential, we have to make these court records confidential. And the judges are doing it. So I'm just going to throw that out as another idea. When we're making it, we have an order we file. We also have a motion to make the records to dismiss the case with prejudice and make the records confidential pursuant to Emergency Order 46. I do have that motion, and I can email it to the listserv. I have no problem sharing that. I have no problem sharing anything, and I'm just going to be honest with y'all. It's because when I was learning, I learned it from mostly Trala and Lone Star. Rich, Mark, Fred, and Nelson, they shared items if I requested it, and I'm never going to say no to anyone because y'all are the ones that trained me.
I'm going to pipe up just to with a quick word of encouragement. Maybe we have an emergency order that will expire, presently expires March 31st. And there's language in there that
March 1st.
mandates that any eviction docket allow legal services or volunteer legal service programs to attend and provide a full spectrum of whether it's advice or full-blown representation. If anybody's looking for kind of, a bit more trial experience, if your organizations can get into the county courts at law from a resource perspective, I certainly encourage it. That's one of the, I think, final kind of steps that we're aiming to do as a coalition. I know HVL has been doing that for the Eviction Defense Coalition, and every one of our organizations is stepping up to try to get more of that practical experience. It's invaluable. I so appreciate this presentation that both Eric and Ryan have put on for our staff. And I'll also just chime in and say, as long as we're on Zoom, and we've done this a little bit in the Right to Counsel unit in Houston, we found it very helpful to have somebody kind of on standby by text. Some of my staff attorneys will tell you that they've gotten messages from me in the middle of trial, object, or, this is what you could do, without necessarily co-counseling or actually appearing at that trial. And it will only make for a better attorney. I think that the JP courts are just such a free-for-all, and we get used to that anything goes, that by the time you go up to county court, you may be really comfortable with the lack of rules, and it's important to know those rules. Don't be afraid to try the objections. Don't be afraid to try your hand at different tactics. That's the best way to learn.
Yeah, just don't piss off the judge
Well,
Ryan.
unless you want to.
too much. Yeah.
But I will
It's a
say,
strategic decision sometimes.
I had a coworker who said that you haven't been to court if you haven't been yelled at by a judge. So, and I will tell you, the first time I got yelled at, it made me, I was like, okay, it's, got to do it.
Yeah. Or you haven't been a legal aid lawyer until you've been accused of being a volunteer. But as I was, yeah, one of our JPs tried to discount my argument because I was a volunteer, and he had been. I'm sure we've all gotten the "I've been a lawyer for 30 years" speech from a judge, right? That's my favorite because it always seems to be 30 years, no matter how old they are. But it is what it is.
There's one more thing I wanted to bring up, Ryan. We were talking about filing answers before, and I mentioned that sometimes I'll file answers just to request attorney's fees. And the reason why we're doing that is because when the other side maybe realizes that they have an issue, sometimes we get competent counsel, they figure out that there's an issue, and they'll just non-suit, and they can only non-suit their own claims. They can't non-suit claims for affirmative relief. And a request for attorney's fees is a claim for affirmative relief. And I'm just curious if you wanted to talk, I don't know if that's enough to be said about that. Like y'all, I'm sure we all work under a lot of the same grants. Most of it had to be returned to the grant funder. I'm not doing it for our sake. Also, sometimes we get pushback on that from opposing counsel or even judges, that whether or not they can even award attorney's fees to us. Nelson once gave me a brief on it. And Eric has provided one more recently.
I've got a killer one. Yeah.
And so just there's very strong case law to support that we should be entitled to attorney's fees. I think there is one instance if it's attorney's fees incurred, and I think that's under the anti-SLAPP statute. Like, it has to actually incur the attorney fees, which is different than the prevailing party may be awarded reasonable and necessary attorney fees. And so just be aware, like under all of our property code, it's the prevailing party may be awarded reasonable and necessary. They do not have to be incurred by the tenant.
Yeah, I had I don't know, a few months ago, I had a asshole JP tell me I couldn't have attorney's fees, so we wrote him a brief, and I think it's pretty good. So if anyone ever needs a brief for us being able to get attorney's fees, I'm happy to share it.
Or ask me for it. I'll
So
share any
didn't
of their
you
stuff.
use attorney's fees and as kind of leverage in negotiating?
Oh, and that's the other thing. I do use
settlement?
it as leverage all the time. I will waive my attorney's fees because if it means that my client gets to stay another month, it is actually sometimes the biggest bargaining tool that I have.
Yeah, that's the only reason I do it. I don't want the money.
Yes. Yeah, I should be clear about that too. Yes. And also then if they owe money, it offsets the amount the client could owe to. I mean, like there are reasons to do it.
Yeah, and they don't know this, but it's a pain in the ass to collect that judgment. I'm not going to record that judgment and go get $200. You
Oh,
know,
but I don't either, but sometimes I just make a phone call and be like, hey, just so you know, you should make that check payable to Houston Volunteer
yeah,
Lawyers.
for
And we
sure.
get a check a week later.
Yeah, sometimes you do, but
I do not waive it at court, Melinda. That's something we do after the fact because as you know, sometimes we win and then the tenant gets a new notice to vacate that day or the next day. And so I'll call the landlord or landlord's attorney at that point and say, hey, can we work something out? And they'll be like, they'll start grumbling. And I'll be like, you know, I might be willing to waive the attorney's fees. And all of a sudden, you know, like they become like very willing to bargain. The attorney's fees is causing the landlord to appeal. Wow. I haven't had
Okay.
that issue.
So I will say this, we had this happen. If the landlord appeals and they don't do it with an IFP, the tenant has to file an answer with with County Court at Law within 8 days of it being transferred if they did not file an answer in JP, even if it's the landlord who appeals. So make sure that if a landlord appeals on you, you file that answer within 8 days of it being transmitted.
Could receiving a notice to vacate right after winning at trial be considered retaliation?
Only if it's legally retaliation.
So I would go look at the retaliation. It says if rent is owed, and maybe if you're saying it's the same day, maybe rent's not owed. I've never done that, and my clients love to tell me it's retaliation.
Because it is.
It's legally,
but
almost never retaliation. So
they're still retaliating.
yes, for sure.
So it's understandable. Tenants don't get that. It's one of many things that, you know, it's not, it's a difference between logical and lawful, you know.
I'm wondering though if they did it the same day. Oh, funny story about giving the notice to vacate at JP Court. I once won because they put the notice to vacate in the, you know, the slit between the door jamb and the door. And the client called me when she got home and said, when I got home, there was a notice to vacate on the outside of the door, the slit of the door, and the inside of the door.
It's not as good as you got home and they did it the same way. Because I've had that happen.
Winning at trial, I don't know if, but so normally when we're, not always when we're winning. We're winning because of things that we've brought up today. They don't have their franchise tax. They're not allowed to continue. They don't have a DBA. The notice to vacate was effed up somehow. So I don't like, even though once we have that, and the other thing is at JP Court, because it's so often dismissed and not a judgment, I don't think there's a res judicata issue. And so I'm enjoying the back and forth and I love you pushing it, but I'm not persuaded yet that it's legally retaliation.
And if they owe rent, it definitely isn't. So, and usually that's why they're getting evicted. So
I did have a client once also come home and she was being evicted for non-payment of rent, but their accounting was screwed up. And she had it proved, and she had actually overpaid. And like that's only happened once the entire time I've been practicing. And when she got home, there was a new notice to vacate with her court fees. So you need to pay us the court fees. And that was hilarious because somehow they also engaged counsel at that point. We told counsel what he did. He laughed and chuckled, like one of the best opposing counsel I ever had, and goes, gonna have to talk with my client.
Yeah, we're seeing that a lot, that they're putting court costs on people's ledgers, even when they lose,
Mm-hmm. Mm-hmm.
especially if you lose.
Oh, and I was just gonna say, I saw an interesting provision once, and I don't know how many properties this company has in Texas. I saw it this week, where in the special provisions on section 9 of the lease agreement, and y'all should always read the lease agreements because there's
If you
some
can.
shady stuff in them. But in special provisions number 9, I'm just gonna point out this person's rent is $9.89 a month. The late fees are $100. And then under special provisions, it says when rent isn't paid by the 3rd, rent increases by $100. And if rent still isn't paid by the 16th, then it increases to $200. This is not a late fee, but a reasonable estimate of the administrative and legal cost regarding the, I don't remember what it said, and legal cost. And sorry, I know that we're still recording, but I'm going to go ahead and say it anyway. As you say, this is not a late fee. Oh, I love you, Ben, or Eric, whoever did that. I just want to, sorry, y'all are posting articles. I just want to point out that just because someone labels it as something different, you have to look at the plain language of it. It was so clearly a late fee. Thanks for sending. Also, there was a opinion piece published in the New York Times today, and it was co-written by Nathan Hecht, our Texas State Supreme Chief Justice, who said that, and the title of it was "Eviction Shouldn't Take 10 Minutes." I might attach that to when I send out Ryan's presentation. I might attach that to it as well. I'm hoping that sometimes we can give a little bit of humanity back to the people who are being evicted, because I've read that judges say this is the hardest part of my day. And then I'm like, well, then maybe I should follow the law and not evict people as much, you know, or listen to our arguments. If this is the hardest part of your day, then listen to us, help you make it not so hard. So, thanks. Eric was quoted in that article. I read it today also. I feel like I'm rambling at this time, and we have 3 minutes left.
Yeah, okay, well, I mean, I don't have anything else. Thank y'all for coming. I hope it was helpful. You know, keep fighting the good fight. This is guerrilla warfare, and we have to use all the tactics at our disposal. And you know, I know all of us are always here for questions, and I'm happy to send out the brief and the plea of the jurisdiction, or I'll send to Lisa to send out the package of materials, and I'll send out the PowerPoint because Lisa's running the show. We're just here for the ride. All right, thanks y'all. I'm gonna call it quits. And again, if it hopefully it'll send it to everyone automatically, and if the chat doesn't send to everybody but it does send to me, then I will send it out as well.
If you want, oh, you mean as part of the webinar?
Yeah.
Okay.
All right. Bye
Good
all.
weekend.